And kia ora. Welcome everyone to this hearing. No mai, haere mai, kia koutou katoa. Welcome to the hearing. My name is Greg Hill. I'm an independent hearings commissioner, independent of the council. I've been delegated to hear this application and to make a decision on it. I'll cover off the hearing procedures, but before we do, I'm just going to hand over to Ms. Ryburn just to cover health and safety issues first. Thank you.
Morena koutou, I'm Natasha Ryburn, the Consents Manager here at Western Bay District Council. Welcome to the Newnham Park hearing. Just a few housekeeping, health and safety matters. First up, in the event of an emergency, please go out the main doors that you came in through this morning and gather in the staff car park area, which is sort of to the right as you go out the main doors. If in doubt, follow staff, which is either myself or Nancy, our hearings coordinator in the just behind here, or Horowai, who's helping with our technology today. Just a reminder to please sign the register that was on the right-hand side as you came through into council chambers just before. Just feel free to do that in the break. We have tea and coffee also outside in the immediate foyer area, outside chambers, and toilets are also out on the left-hand side out in the foyer area. Just a reminder, we are live streaming and recording this hearing today, so it's really important that you turn your microphone, and for everybody in this room, to turn your microphones on when you need to speak, and it's the right-hand button, which is basically how you turn the microphone on and off. Look, if you have any questions, please don't hesitate to talk to either Nancy, myself, or Horowai during the proceedings today. We are here to make sure that everything runs as smoothly as it can. Thank you.
Thank you very much for that. Just one other reminder, can people just make sure their cell phones are switched off or on silent so we don't get disturbed? Thank you. As I said, my name's Greg Hill. I'm an independent hearings commissioner to hear and make a decision on this application. I accept that this is quite a formal setting and I will try and run the hearing as informally as possible. This clearly is an application. Hope you had all the material from Newnham, and we've got the council officer's report, we've got all the expert evidence, the legal submissions, the submissions, and I've got some speaking notes, which we'll work through the day. We've got a schedule, which I'll follow pretty much. I think I understand that times have been broadly allocated as well as to submissions. And just to cover off for those who are not familiar with the hearings process, the way that I'll run the hearing is I'm going to come to the council officers first just for a couple of clarification questions that have arisen in the section 42A report. It's the report that the council or Mr. Whitaker has authored. We'll then come to the applicant and we'll hear from the legal submissions and the witnesses that Ms. Ham will be calling. I am able to ask questions of the applicant. Submitters are not able to ask questions. There's no cross-examination here, but if there are particular issues, we may be a bit flexible there. Once the applicant has presented their case, we come and hear the submitters, and I've got a list of those. And the same process applies. Submitters will present to me. I can ask you questions, and again, the applicant cannot. It's not a cross-examination like in a criminal court situation. Once the submitters have been heard, we then come back to the council officers who have drafted the report for them to make any comments in relation to what's been heard in the hearing. And again, I can ask them any questions that they may have. And following that, we come back to the applicant to cover off effectively what's called a reply to address anything that has arisen in the hearing as a result of evidence heard or questions from me. And then at that point, well, I'll come to Ms Ham whether she intended to do her full reply today or in writing, but we'll come back to that a bit later. And following that, I'll adjourn the hearing. And then once all the material is in, I'll close the hearing. I'll advise the council when that is. And following that, under the Resource Management Act, there's 15 working days in which a decision is to be issued. Are there any questions just on that process? Is anyone unclear on how it's going to be run? It'll be reasonably structured, so we can come along. So that's fine. Thank you. We've got. I think we're going to comfortably get through the hearing today. I mean, that's certainly my intention. Tomorrow was set aside, but I don't think we're going to need that at all. The other thing is a site visit. I undertook a site visit yesterday. Had a look at, walked around the site, walked around the area, had a look at where the submitters' properties are. So I have a general familiarity with the area. Again, we've got the schedule. Breaks are scheduled 10:45 to 11 for morning tea and about 1 to 2 for lunch. But again, we'll just find convenient places to stop. I note that overnight, a number of speaking notes have come in from submitters. I think Ms Kane, we've got from you and Mr Jones. I've had an opportunity to skim them. I'm not sure whether Ms Ham, you've probably not had an opportunity to look at them. What we'll probably do, we could take slightly longer breaks just so that they can be read in advance. It's been really useful to have all the material pre-circulated. Thank you for your legal submissions and the evidence. It's all the material that has been pre-circulated, other than what came in overnight, I've pre-read. And as we've said out in the directions, don't need the statements to be read out. What I'm hoping that the witnesses will cover off is sort of any highlight of issues, and we'll go to questions. And hence the same with submitters. So I'd like to be able to read the statements so that I can kind of engage a bit more rather than you just reading out your material, which tends to take time and doesn't actually get to the heart of what the issues are. So when we come to the submitters, what I'll ask is that they're not fully read out, but we'll go to questions to cover off those issues. I think that's all I need to cover off in terms of process. Again, I just want to cover any issues of concern, any issues parties don't understand what's going to happen or how it's going to happen. No, great, let's get underway. Thank you very much. As I indicated at the beginning, I just wanted to come to, one other thing I should just cover off. I just want to make it clear too that the council, the report, the Section 42A report that's been prepared by Mr. Whittaker and the other experts, to make it, that's their opinion. It's not the position of the council. It's the expert opinion, and that's what I'll be looking at. So the council per se does not have an opinion on these matters. Of course, if a decision is granted, if the decision is granted to approve the application, then it clearly does become the consent of the council. But at this point, we're dealing with the council's experts and their expert opinions, and the same with the applicant's experts. In the Section 42A report, and this is a question for Mr. Whittaker, is essentially saying that, in his opinion, the application can be approved, but there are a couple of outstanding matters, particularly around the issue of traffic and the financial contribution and the sort of hours of operation. And in the report said there's going to be engagement further with the applicant. So Mr. Whittaker, I'm just wondering if you want to just update me on where that's got to. Is there an agreement, and have you got a particular opinion about whether a financial contribution should be imposed or upgrading should be, roading upgrading should be imposed, noting that Ms. Ham's addressed this in her legal submissions?
Thank you, Mr. Commissioner. Since the Section 42A report was issued and through the preparation of the applicant's evidence and the supplementary statements that have been presented by council, there have been ongoing discussions between council and the applicant in terms of understanding the traffic generation effects and the methods by which those effects may be addressed through upgrade conditions. I think. talk more directly into the microphone. So there has been some constructive engagement and discussions around the eroding effects and the measures that may be available to address those. At this stage, there's no agreement which has been reached between council and the applicant. So essentially, there still is the position that council is seeking more substantive eroding upgrades, either in terms of a widening of Newnham Road to a 6.5 metre carriageway. However, the alternative and preferred option remains that the existing carriageway is retained and a separate shared path is formed. And as I understand it, the applicant's position still remains that they are not accepting of that at this stage, although I also understand that there is very much a willingness between the council and the applicant to further work on whether there could be an agreed resolution on the roading upgrade matters. The only other thing, Mr. Commissioner, that I would like to highlight is that in the Section 42A report, I did raise a potential issue of scope. And the only reason I did that is that in the context of this application, it essentially has replaced an earlier application which is still on hold. And this application has purposefully or deliberately removed the earlier roading upgrade measures that were formed part of that application. That matter has been addressed in the legal submissions from the applicant. I'm a little bit unclear on the legal position of the applicant and whether there is a scope issue that is live. I think the applicant's position is that there is a scope issue there, which goes beyond considering the merits of the any conditions and expert evidence on their merits. So I think that's a matter that still needs to be considered by the Commissioner.
Thank you. I mean, Ms. Ham will cover that scope issue, but I've just got a question. So in terms of, thank you for that, that's helpful. I mean, and I think the issue, certainly between the experts and the issues, put aside the scope issue, seem to have come down to this issue of transport seems to be the major issue, and what is an appropriate form of condition or conditions should consent be granted. I want to make it clear again to submitters as well that I will be talking about conditions of consent because conditions of consent form part of the application and form part of a decision if one is to be made to grant consent, and the conditions are how effects might be avoided, remedied or mitigated. The fact that I'm talking about them is not a fait accompli that a decision has already been made, but I need to discuss those in this hearing because this is the only opportunity I have. It's a public forum and there are not discussions with me behind the scenes about how things can be panned out. So just bear in mind, I will be talking about conditions. Mr. Whitaker, so can you introduce the rest of the team? Ms. Brown, and Mr. Telford, is he here?
He's still on his way.
Oh, he might come. Ms. Ham's raised, I had read it, when I read the report, I thought the same thing, and Ms. Ham's raised the same issue about this idea of double dipping. So if I were to grant consent and were to impose a financial contribution, is it your professional view that then you would not impose other road upgrading conditions and vice versa? It's one or the other. I know the applicant's position is that probably certainly the financial contribution is not justified, and Mr. Carlisle's evidence is that the adverse effects are no more than minor, and therefore there doesn't need to be conditions about that.
Thank you, Commissioner. I actually have prepared a supplementary statement to address that point, but essentially I don't believe there is any proposal for double dipping. So in summary, the Council's position is that there needs to be physical upgrade works on Newnham Road to address the safety and efficiency issues directly arising from the additional traffic generation. In addition to that, the District Plan provides the assessment of capacity consumption across the rest of the roading network. And so essentially what the Council's position is that there should be conditions in terms of physical upgrade works on Newnham Road. No financial contribution for Newnham Road, but there should be a financial contribution for the capacity consumption on the remainder of the roading network, and that's set out in the updated financial contribution memo.
And the reason I wanted to ask Mr. Telford, because I know that you're a consultant to the council, but if a financial contribution were to be imposed, as Ms. Ham has set out, and as I understand it, the financial contribution would have to go towards the actual upgrade to which the effect occurs. How does that happen? I'm not sure that you're probably not the right person to answer that, but I'm assuming it doesn't just go into a pot or a pool, and when the council decides it's time to upgrade the roads, it will then use that money, because that clearly doesn't directly address the effect. So, and I think this is some of the concerns that Ms. Ham's raising, which she'll cover off, but I just want to know what the council's view of that is.
Thank you, Commissioner. I have had discussions with a number of council staff in terms of the financial contribution provisions within the district plan and the mechanics that are set up behind those in terms of the collection of financial contributions. Very much in terms of this case, council is not proposing or recommending a financial contribution for any works or a contribution to works on Newnham Road. Because what that would mean is that, yes, that money then has to be kept ring-fenced for those works, and then council essentially has to fund or top up any additional funding of those works. So in this case, the council's position is that if consent is granted, there should be specific conditions for physical upgrade works for Newnham Road. In terms of the capacity assessment, that's essentially for Snodgrass Road. I'm not the best person to answer that question, but my understanding is that that does go into more of a generic fund for road upgrade works across the catchment.
My final question before I come to Ms. Ham is, if consent were granted with road upgrading conditions on them, given the road is the council's and the applicant owns private land adjoining it, is it the responsibility of the applicant to actually do the physical works, or does it need to have that done through the council? i.e. the council will do it and the applicant needs to fund it?
My understanding is that there would need to be, if the conditions were imposed, essentially setting up the nature of the upgrade works, then there would have to be detailed engineering drawings submitted for approval by council, and then there would need to be an approved contractor that would carry out those works. So I don't think it would be council doing the works.
Thank you. That was helpful for me to sort of frame that. Thank you very much. Ms. Ham, I'll come to you. And again, I've read your legal submissions, and I'm happy for you to step me through. There are some things in there which I can clearly agree with you on, and others will be more where I might have some questions.
Certainly. So, as you've had a chance to read everything, I'll just touch on the highlights in the submissions, and then I'll talk a little bit about this question of road upgrade versus financial contribution. So in terms of the highlights, for the applicant, I say that there is evidence before you as to actual and potential effects, and that those are acceptable, and that it's also not contrary to the objectives and policies of the plan. Because of the history of this application, there are some issues surrounding the existing consented baseline and the relevance of that to your assessment, and also the relevance of the historical exceedance of some of the limits. The National Policy Statement for Highly Productive Land is also an issue. And then finally, the conditions, which I'll deal with most fulsomely at the end. On the question of the existing environment, and I don't think there's a lot of dispute about this between the applicant and the council, and necessarily even with the submitters. So I've set out in my submissions what I think that is, and that is that all buildings on site are consented except for building 5 and some storage units. There are some limits around 3,000 tonnes of puree processing annually, 5 tonnes of vanilla beans annually, processing of fruit and vegetables, consultancy, marketing, management and research services, and orchard management services. And there are limits around 42 staff and 53 car parks. On vehicle movements, 108 vehicle movements per day. That's comprised of 84 staff, 8 truck and 16 visitor movements, and operating hours of 7 a.m. to 7 p.m. Monday to Friday. And I don't understand any of that to be in disagreement, at least with the council. I have to acknowledge for Newnham Park Limited, and it acknowledges that there have been exceedances of that consented baseline over the last few years. Unfortunately, Robotics Plus, which we can claim as a success story in the Bay of Plenty, it's been bought out by Yamaha, and it literally started as 2 or 3 people working on the site. But unfortunately, or fortunately, it became very successful, and that led to numbers ballooning. And Newnham Park Limited has spent approximately 5.5 years trying to regularise the consented position. This is not the first application that has been made, so you will have apprehended that there is another application on hold with the council. But with robotics moving out earlier this year, and so numbers drastically reducing, through this application, Newnham Park is seeking to provide for some growth, but at a much more modest level. So in terms of staff numbers, for example, the maximum sought is 75, which is, in my submission, a modest increase. Now, I make the point, and there might be some dispute about this with the submitters, that whilst the applicant can't claim any benefit from having exceeded those consented limits, neither in my submission should an artificial approach be taken. And it is my submission that it would be artificial to completely ignore the fact that Newnham Road has coped with a substantially larger amount of traffic than the applicant is now seeking to authorise. And in my submission, that just is another factor that the Commissioner can consider when considering the effects assessment before him in relation to the application. The second matter I'm going to touch on is just the question around non-compliance, because I expect there will be some strong submissions from submitters that there is a penalty or this application should be viewed unfavourably as a result of that. It's my submission that the applicant is entitled to the presumption that it will comply. There's long-standing Court of Appeal authority on that, and I've cited that in my submissions. I have noted for completeness that the provisions in the Natural and Built Environment Act have remained applicable around decision makers taking non-compliance.
It was very interesting reading that, and I was thinking, oh, that's a bit scary.
It is. The point I make is that the Western Bay of Plenty District Council has not taken any enforcement action against my client. So on that basis, that is not an issue for the Commissioner. And I'll leave that point there for now, but I expect that might be an issue raised through submissions.
Can I just say, so on, and really for submitters' benefit as much as anything, I accept the argument about the existing baseline. There is a consented environment. There are a number of consents which are in place which enable your client to operate. So in the basis of law and certainly my consideration, that becomes a starting point. I understand the point you're making about the operation has operated beyond that, and what you're already saying to me is I can have a look at that and say, well, there's been a level of effect which you can actually know because it's actually happened. So we'll consider that. And I do accept the argument as well. And again, I put this to the submitters. I understand it's come through in the submissions and come through in the speaking notes about this frustration with the application about it's operated beyond its consent that has been granted. Ms. Ham, in my view, is right in terms of the law, and the case law is I am not able to take that into account. It is the role of the council to take enforcement action against New Investments Limited had they wished to. And I know that Mr. Jones and others have got quite lengthy submissions statements in there about the efforts that they've gone to talk to the council about. But for me, I'm not able to take into account the fact that they have operated beyond their consent.
I'll turn now to the National Policy Statement on Highly Productive Land. So this is a matter which the Commissioner has to have regard to, but I note that it's not a plan change, so there's no need to give effect to it. It becomes one consideration. And to that extent, the Commissioner's inquiry in my submission could start and stop with having regard to the objectives and policies, although I go on to discuss the other pathways. And that's because the productive capacity of this site is effectively already constrained. It was originally a pack house. Newnham Park has developed there. I mean, it's been in that shape for around 30 years, so it's not a new loss of highly productive land. Additionally, the alterations sought through this application are very small. So for those reasons, I say the application is not contrary to the objectives and policies of the National Policy Statement for Highly Productive Land. But if there is a need to go through the exceptions, then there are two available, and those are the small scale exception. And again, that's really because the productive capacity of the site is already constrained, it's already built upon, and the scale of this application is small, so that's not going to really change things. Alternatively, there is the pathway under 310 around economic constraints. And again, it's really the same point, that the park is already developed, the productive capacity is already lost. In this case, obviously, if we start to talk about, are we going to return it to productive capacity, well, then that raises other effects around the loss of a very successful business park. So in my submission, those pathways are available, but fundamentally, I say it's not contrary to the objectives and policies of the National Policy Statement. I'm going to turn now to the question of conditions and financial contributions, and I think just recap the sequence of this from the applicant's perspective, because we received Mr. Whitaker's Section 42A report, and within that was Ms. Brown's technical memorandum, which concluded, well, widening was required, but rather than widening, a shared path would be preferable. At that point, there was no financial contributions assessment available. So that landed with us literally as we were finalising our evidence. And then on Friday, we received a supplementary statement from Ms. Brown, which in respect of the shared path gave some square metre rates for concrete or metal. And we received a revised financial contribution calculation. So we have been trying to get our heads around how those things relate to each other or not. If I deal firstly with the evidence of the traffic engineers, Mr. Carlisle's evidence, and you'll hear from him, is that the road doesn't need widening, some safety improvements would be merited. Those are things such as speed humps and signage to reduce the speed. Against that, we have Ms. Brown's evidence saying that widening is needed, but the creation of the shared path is better. Other than the square metre rates, the applicant has no notice of what that shared path looks like. So what side of the road is it on? What sort of formation is required? What is the width of it? What is the surface? My thoughts on that are that, and having been to the site, you will have appreciated that Newnham Road is a much smaller rural road than the other roads around it, including Burrell Road, which you might have gone down, which has the cycleway on it. That's a much wider road. It's got lane markings. It has a formed concrete path, which the cyclists use. But my submission would be that once you get to Newnham Road, which is much smaller, it's slower, and the cycle path at the end of Newnham Road is metalled, if the Commissioner is minded to prefer that evidence of Ms. Brown that a shared path is appropriate, then my submission would be, well, a metalled path would be appropriate, not a concrete path. Now, there's no detail around how long that is or how wide it is. I note from the financial contributions assessment that the carriageway for Newnham Road appears to be 368 metres. So, you know, a rough order of calculation, if I were to multiply 368 by a 2 metre width and assume the higher metalled rate of 50 square metres, that gets me to 36,800. So I'm not sure if that's the order of costs we're talking about or not. If I then turn to the financial contributions calculations, there's a Snodgrass Road component and a Newnham Road component. So what I understand Mr. Whitaker is saying is that the Newnham Road component would not be included in any financial contribution imposed. So taking that on board, I suggest there are 3 options to deal with this, which I'll propose now and then come back to those and reply. So one option would be that Newnham Park just pays the FinCo, which the council has calculated, including Newnham Road. So that's 119,000. And there's no separate condition requiring a shared path, but the council could use the $48,000 component for Newnham Road to build the shared cycle path, and based on my rough calculations, that would appear to be sufficient. Option 2 would be to impose the FinCo for Snodgrass Road only, and then basically separate out the Newnham Road and have a separate condition offered by Newnham Park for the 36,800, if that's what we're talking, but specifically that shared path component. The third option I suggest would be that Newnham Park pay the Snodgrass Road financial contribution and the safety measures suggested by Mr. Carlisle are implemented, because I think there is still an evidential decision for the Commissioner as to which of those options you prefer, the shared path or the safety improvements. So there's some options there, but I think it would be useful to, perhaps for the applicant, to discuss that with the council directly throughout the day.
I think that will be useful. I think what you're signaling is that your client is not opposed to some form of condition. It's really coming to some form of agreement between what is acceptable between certainly the applicant and council.
That's right. At the moment, it's completely undefined. So if we can put some definition around it and understand what the commitment is, then I think we can start to get there.
Oh, I understand that.
So that's all I propose to say in opening. I have 4 witnesses. So Mr. Jeffrey for the applicant, Mr. Hegley will be online for noise, and then Mr. Carlisle, the traffic engineer, and Ms. Hazen, the planner, are here. Mr. Coombs is available if you had some questions for him. I can arrange for him to be available around midday.
It's fine. I think I do have a question for Mr. Coombs, and it's in relation to statements that have come in from the submitters around visual amenity. And so it would be, if you want to just relay back to Mr. Coombs, it's if he could read the statements that came through, particularly the one from, I think came in from Mr. Jones. There's a 32-page statement. There's 2 aspects. There's amenity and then there's sort of visual and reference to the ISMIS report. And it will be, the question really is for Mr. Coombs to confirm whether his view remains the same that's in his evidence, that from a landscape visual point of view, this proposal is acceptable for all the reasons set out in his evidence and in that report.
And I should say, and I'll just say it now out of fairness to the submitters rather than save it for reply, but it appears to me that the group submission is a reproduction of the submission for the prior application. So obviously this application is of a much lower scale, and you may have questions for them about that.
And that was my reading of it, and I'll ask that question when we come to it, because it appears that so I wasn't sure how much of it was reproduced. of the original application. Certainly, I think, is Mr. Jones here? Not yet. Oh, yeah. Well, I'll come to this later on. It appeared that, the Inspire and the planning assessment you've had done with the date on it seems to apply to the earlier application. Right, okay, so we'll just be able to cover that off when we come to hear from you later on. Okay, that's fine. Ms. Ham, do you want to address me on this issue of scope? Because I hadn't seen there was a scope issue, in the sense that this application for me has been notified and assessed as this application, accepting that there's another application sort of sitting in the wings, which is not unusual. And I know that Ms. Hayson, in her evidence, and certainly in the draft condition, says it's the intent of the applicant, and I can't remember whether you said it in your legal submission, that if this consent is granted or application is granted, it's the intent of the application to withdraw the previous one. Now, again, strictly speaking, that's not relevant to me, but do you just want to comment on the scope issue?
Yes, so sorry, and look, I might have misunderstood. I might need to check with Mr. Whitaker's point on this. The way I see it is they are two separate applications. This is a separate application. It's been notified. I'm not understanding what the scope issue is.
Let's just deal with that. Mr. Whitaker, do you just want to explain again to make sure that we're both understanding correctly?
So the only issue that I thought was potentially a scope issue is that in the current application, the applicant has put forward a proposal which has deliberately removed the road upgrading proposal. So in the earlier application, the road upgrading proposal was part of the application. That has purposely been removed from the current application, which we're hearing today. And I just wanted to raise it as a potential scope issue in case the applicant took the view that you can't impose a condition for road upgrade works, which we've deliberately or purposely removed from the application. So if the applicant's not saying that, then I don't think there is a scope issue.
Ms. Ham might want to make that, yeah.
I'm not saying that. What the applicant is saying is that based on the effects of this proposal, widening is not required. Now you have, evidence before you from both the applicant's traffic engineer and the council's traffic engineer. They land in different places, and it will be your decision. And obviously I ask you to prefer Mr. Carlisle's evidence on this, but I think you will have to make a decision either way as to whether the safety improvements which Mr. Carlisle recommends or the shared path are preferable. In any scenario, we don't appear to be talking about actual road widening.
I understand that, thank you. But just to clarify then, so in terms of the further discussions with the council on what appropriate conditions will be, given what you just said about preferring Mr. Carlisle's view, you'll only know that once I've either issued a full decision or interim decision. Are you asking that I do that before you go into discussions with the council, or are you suggesting you go into council and come up with an agreed set of conditions, which may in the end rely on both sets of traffic evidence, where the applicant simply comes to an agreement with the council and say we're happy with it?
Look, I think if we were able to reach an agreement with the council, then we would advocate for the agreement, but we're not at that point at this stage of the day.
So the process will follow then. We'll probably have the hearing, we'll get to the end that whether you can reach an agreement today or sometime after that, then you'll write back to me and say an agreement has been reached, and if you're going to grant consent, this is the condition that we've all agreed, or we have not reached any agreement and we ask you to make a decision based on the evidence before you.
Yes, and so probably just to round that off, that's where I come back to the optionality. So I think there are options. So for example, with the FinCo, if we put to one side the calculation that came through that included Snodgrass Road and Newnham Road, it appears we're now just talking about Snodgrass Road. So then the options become either a separate contribution condition for the shared cycleway or a condition for the safety improvements recommended by Mr. Carlisle.
Understand that, great. Do you want to call your witnesses?
Yes, thank you. So my first witness is Mr. Jeffrey, who's seated to my left.
Welcome, good morning.
Morning all. I'll just briefly go over tonight this year. Yeah, I'll just go summary. I've been the director for Newnham Park for the past 15 years. The park itself's been there for 30 years, and buildings in that prior go back to the late 60s, early 70s. So the actual park itself has been around for quite a while now. I took over from my dad when just prior to my mum passing. It was a couple of years later, and I saw Dad was actually struggling a little bit with it. So I stepped in and as family decided that, you know, somebody had to step up and help Dad out there and took the park forward. So it was a bit of a trying time, but a lot happened over those years, and we move on. At that time, we had robotics there, which has been a bit of a contention in this consent. There was about 3 people working for them. I remember them vividly sitting in the corner there asking if there was going to be ever growth for them. And from there on to around about, I think it was 2018, I'd been down at council quite a few times prior to that and shown them what was going on in Newnham Park. So they were fully briefed on Newnham Parks, whether it be expansion or growth that was happening. Robotics started to exponentially grow, which got out of control in terms of us being able to handle, and I think any developer. Briefly after that, we applied for a variation for one of our tenants, Kiwi Fruit Processing. That was granted in 21. And then around later that year, we looked at consent, doing a resource consent for 45, to expand into 45 to try and cope with our exponentially growing robotics. And shortly after that, that national policy statement came in. And that sort of put the kibosh on that, really, because there was a major change right across New Zealand in that. From that, we had a pre-hearing. We listened to that. We then went back and we re-looked at our consent. And at that time, we changed and we realised that we couldn't cope with robotics expansion, and we had to let them know that they had to seek new accommodation. Now, in doing that, that was a 2-year path for them by the time they went through the consenting process here and getting their buildings done. So we coped with them and had to work with that as to work with their exit out of Newnham Park, which I think you did see when you were out there last. Since then, with their staff leaving and that the park has considerably come back to its consented size now within its staff numbers, its car park numbers. And doing that, that application for that resource consent was put on hold, which Vanessa has discussed. And then we went back, we looked at what the pre-hearing presented to us, and we presented a new consent that does constrain Newnham Park within its boundaries now, does not exceed onto 45, and we're allowed for a little bit of growth. Now, when we say growth, that's just within our actual building 3. 2 buildings are being removed and a car park being built to cope with that, and that's totally understandable. So today, and you would have seen when you did the site visit, robotics has exited. The staff numbers on site are 46 or below. Pretty sure people do go to work still. The car parking is removed from the roadsides and any other area, and we've regrassed the front of the roadside. The tenants on site, they are connected with the horticultural industry. We have our 4 tenants, Kiwi Fruits, which does the pulping processing, Southern Produce, which is one of your largest avocado exporters, Tiny International, who does the cloud-based management software for the agricultural industry, and Halal Vanilla, who processes vanilla beans out of Tonga. So that's the site as of today. The only remark I'd like to make at the end, I'd like to read this if that's possible. And this is from one of the submissions. This is a statement here. For the reason I don't think the amendments suggested by the Langleys in their submission to limit management administration activities to those which are small scale and auxiliary to the on-site activity of processing its storage of agricultural products to be necessary or desirable amendment, as this would preclude some of the current tenants whose businesses support the rural and horticultural sector. The second one, any issue which is raised in submissions in the weekend activity. I am not comfortable with the amendments suggested in the Langley submission, which is to limit weekend activity as follows. Weekend activity only where it relates to staff and traffic movements directly associated with the movement and processing of locally harvested produce during the harvest season. We do not wish to restrict our tenants from undertaking activities on the weekend in this manner, as such wording would preclude for example, one of our office-based tenants from coming in on the weekend to do work. This type of activity is not causing any harm to anybody. In addition, the gardener and the man who mows our lawns currently do that on the weekend, and which would not be provided for in the Langley's proposed changes. And then, as I said before, they follow up on our changes with removing building 1 and 2, which I think we're happy to do to bring the park in line with the pre-hearing requirements. And I think just to finish, the activities on site are currently within the limits of our 2013 resource consent. But to ensure the consent terms are fit for purpose, enabling some limited expansion, we ask for the ability to have our site staff of 75 with the site staff of 75 with associated traffic movements. So that's what we're proposing from our.
Thank you for that. A couple of questions from me. I understand your statement. In Ms. Hayson, attached to her evidence is a set of conditions that if the application were granted, is what she's saying is appropriate. One of them is this community liaison group. The question I've got from you is, do you support that as a condition? And I'm assuming I'm going to put the same question to the submitters. I'm assuming it's come through from this concern that this is an application which is outside the norm in the sense of it's a non-complying activity. And I got a sense that partly because Newnham Park had operated outside its consent conditions, there was this whole suggestion that the community should be at least involved in how the operation is undertaken. So is that a condition you support?
I don't have any issues with that condition,
right,
actually.
Right.
I think interaction, we have opened the park many a time over the years,
right,
and invited neighbours in. So they've seen what's going on. We have no issues with it at all.
Okay, right. And the second one is, again, just thinking about the numbers of people on the site at any one time. Again, Ms. Hastings, in that recommended set of conditions, this is number 12, where in terms of weekends, she's saying 8 people, and then public holidays 1 person. I haven't gone back to the actual application to see what was actually proposed, but does that fit with what you've just said about not wanting to limit your tenants? And are you happy to live with those numbers should the consent be granted?
The weekend, the one comes to the weekend you're talking about, they're having a few people on the weekends,
Yeah,
just allows the tenants to, in case of emergency, I mean, our gardeners and that, they like to work the weekends, which I can't see an issue in the area. In terms of the main tenants, that allows for during the produce season, harvest season.
So the answer is yes, you're satisfied that if consent granted, that those numbers are appropriate for you. Okay, no, that's fine. The final question I've got for you, it's interesting that a number of submitters have raised this issue of the green wedge and the Te community plan. And again, Ms. Hastings set out in her evidence that plan specifically identifies Newnham Park as a as a current operation and expansion. Were you involved in that plan?
That's quite me.
It's not super material. It's sort of just an interesting. Again, Ms. Hayson notes it's not a statutory plan, but it's sort of a document which clearly is trying to set out how this area is to develop with this green wedge.
That's the original community plan.
Yeah, well, I think it was developed in 2017. If you haven't got it, it was just that in a couple of places it actually specifically mentions Newnham Park and it talks about amenity and it talks about its growth. So I just wondered whether you had been instrumental in that plan.
Wasn't instrumental in it. I do remember that. Remember reading the article in it that we were mentioned in it, and that's about as far as I can go with that.
Thank you very much. Thank you.
Now I was going to call Rhys Hegley next, who hopefully is online. Is he? Mr. Hegley.
Good morning.
Good morning. Now Commissioner Hill has read your evidence, so if you could just give a brief highlights and then he may have some questions for you.
Thank you. So just to summarise, the proposal is really a modification of what's already there. There's cars coming and going, trucks coming and going. They'll be loaded, unloaded with forklifts, and there's a menagerie of refrigeration plant around the place. This has made the prediction of noise reasonably easy because we've been able to go to site and measure what's going on and use that for our predictions. That's led to some mitigation being proposed, and namely it's 1.8 metre fence down most of the western boundary. There's screening to some of the plant, the northern end of building 7, and the requirement not to have tonal reversing alarms on the likes of the forklifts. And that's not a condition as such, the reversing alarms. That comes through in the condition for noise management plan, and that management plan refers to the reversing alarms. And all of this has led to quite ready compliance with the district plan noise limits. I think during the daytime, the upper limit is 43 decibels, and that's predicted to the eastern 19 or 27 Newnham Road. And then at night time, the uppermost level is 35 decibels, which complies with the 40 dB limit, and that's over to 47 Newnham Road. That compliance has led to the conclusion that the effects are reasonable and appropriate for the area. The one submission that really addressed noise was that of the Langleys, and they had 2 comments. And the first was the car parking on 45 Newnham Road. I understand that's not part of the proposal. That'll be removed. And bins being unloaded, and that activity will now occur behind the fence, which will reduce the noise, and further into the site, which again will reduce noise further. So I think that addresses that issue. And my last comment really is on conditions. I largely agree with the conditions. The only comment I had was on condition 19. It gives the noise limits for the proposal, which are just copies of the district plan limits, which I think are appropriate. I think there should be added in there, though, that although the condition refers to the assessment point being the notional boundary, and I think for completeness, we should define the notional boundary, and I'm suggesting we adopt the district plan condition or definition of a notional boundary to be added to the condition. Thank you.
Thank you, Mr. Hegley. I've only got 2 questions. I think one, other than that amendment to the condition that you have suggested, as I read it, there is nothing in contention between you and Mr. Runcie, who's the acoustic expert for the council. Is that right?
That's my understanding, yes.
And the second question is the acoustic or the fence that's proposed on the boundary of the site and 45 and effectively also to 47, which is to be extended, I think, effectively from the road down past building 7. Your view is that fence is not required for noise mitigation, but the applicant's chosen to do it. Is that correct?
Correct, yes.
Are you able to, this is 3 questions. Are you able to offer a view or opinion in terms of that acoustic fence? What impact will that have in noise reduction to 47? You say it's not required to meet the district plan requirements, but to what extent might it reduce noise even further?
It will be mainly effective against the car parking. The original proposal was at our AEE, the fence was suggested to run from the Newnham Road boundary down to the northern end of building 7. And that was really to screen the car parking, the trucks coming and going. It would, normally you say a fence will knock off 10 decibels. I think in this case, it's probably a bit less because the cars are a little way away from the fence. So you're looking somewhere like reduce car noise by 5 to 7 decibels, I'd imagine. In this case, the applicant's chosen to extend it right along the length of building 7 and further south. And there'll be a slight benefit there because there's a mechanical plant on the southern end of building 7. And you'd expect it to knock off a couple of decibels off that too. Not a lot, but you know, it all helps.
Thank you very much. Again, as I said, I only have a few questions, but I think there is no real disagreement between the expert acoustic evidence. Thank you.
No, thank you.
Thank you. So we'll proceed with to Mr. Carlisle, the traffic engineer. He's at my far right.
Thank you, Mr. Carlisle. Welcome. Just before you underway, now you've got the supplementary statement from Ms. Brown, which normally we'd get that a bit later, but the question, what Ms. Brown has raised is questions I was going to put to you anyway, so she's effectively answered them. So presumably you've read that and you'll be able to make comments on it.
Yes, I have some comments to make on key issues, key matters in it. Can you, that's on, I think, yeah. Perhaps firstly, Sarah, I'd like to perhaps just highlight the volumes that are involved here in both the existing environment and the proposed environment. It's a low volume rural road, and that's going to be with or without the effects of this application. So in terms of putting some numbers around that, when we look at the consented baseline, which is 108 vehicles a day from the consented activity on site, plus the background traffic of the neighbouring properties, we're talking about a volume of 168 vehicles a day. Now that increases with the application proposal to 290 vehicles a day. It's an increase of around 120 vehicles a day. So in my mind, we're talking about a very low number of vehicles in absolute terms. Over a day, it's an average of 12 vehicles an hour, and that's less than 1 every 5 minutes increase in traffic on Newnham Road. I consider this to be a lightly loaded road. Similarly, the heavy traffic proportion of the traffic is not a large number. We're talking about a proposal now to go to a maximum of 22 heavy vehicles a day, which again, if you average that out over a day, is less than 1 an hour. In fact, that is the peak. So and there's a peak season, which we have been surveying. That's the peak in May when there's a seasonal effect happening with the kiwi fruit industry primarily. When you average the number of heavy vehicles over a year, we're talking about, and Newnham Park have provided some data on this, we're talking about an average over of about 6 truckloads a day. So the peak of 11 truckloads per day, i.e. the 22 vehicles an hour, is simply that, a peak, an extra 5 on top of the average. We're not talking a large number of vehicles. When we consider, again, I guess, what was the pre-existing environment, and you've heard Ms. Ham talk about before robotics moved out, the road was experiencing a higher volume of traffic, about 350 vehicles a day. We measured back in 2021. We've remeasured that now in May 2025. But if you look at traffic that was experienced by the road, the environment that was happening in 2021, we're talking about a reduction in traffic of 126 vehicles a day from that pre-existing volume. And I guess the reason this is pertinent is that there were no issues raised, recorded by council that I understand in that period. As I said, additional surveys have been completed in May this year, and they have now verified basically my assessment. They've verified our forecast numbers and they've verified the existing environment. I think the nub of the issue in my thinking is that we are in agreement with council that there is no need to widen to 6.5 metres. We seem to be in agreement that the key issue is how to treat cyclists and pedestrians and provide a safe environment for cyclists and pedestrians. My assessment was targeting a mitigation approach that would come up with a solution that would be in keeping with the effects of this development and look after the safety. And hence, I have set out some mitigation that revolves around speed humps to reduce speeds to that appropriate to pedestrians and cyclists. I also think we're in agreement that a safe speed of 30 kilometres an hour is a good target speed for a pedestrian and cycle environment. Maybe at this stage, I just want to also clarify that the alternative put forward by council, I'm not opposed to in terms of a shared path, in terms of that treatment. And if there is an avenue for council to construct that shared path as partly funded or fully funded as set out by Ms. Ham earlier in terms of some of those funding options, then I fully accept that as a valid alternative to my suggested mitigation. My earlier mitigation was targeting cyclists, and I'd have to say we did discuss this mitigation with council back pre-application. And subsequent to that, I have been looking at what I now see as the primary safety concern as being pedestrians on the road. And the reason I say that is that you can accept a greater differential, or the differential speed between cyclists and cut vehicles is less with cyclists than it is with pedestrians. And so because we're now considering pedestrians, and I've now studied the video, quite some video footage of the trips through the day, there is quite a number of pedestrians that share the carriageway. And so I think, again, we're both in agreement that that is a primary safety concern. So keeping those speeds down to 30 kilometres an hour is an important criteria. And with that in mind, and you came back before in terms of Ms. Brown's, what are we calling it, rebuttal or additional statement, that she had some concerns around the speed humps. And one of the primary ones I saw was the spacing of those speed humps.
Just on that, I took it as much more of a fundamental concern about speed humps on rural roads as opposed to where they were. So there was a question I was going to put to you that Ms. Brown clearly doesn't support speed humps on rural roads, and because of the reasons that she set out. These are rural roads and there's large trucks and vehicles, and in fact, it's not appropriate to have speed humps. Do you agree?
I can't agree fully with that. I can agree that they're not very frequent. Do we have speed humps on rural roads? But the key issue being that you wouldn't want vehicles approaching a speed hump at 100 kilometres an hour. And that would be the primary reason why you don't have them on rural roads, because the approach speeds are too high. In this case, we're talking about a road that's already got a posted speed of 60 kilometres an hour. In my mind, I would actually be in favour. In fact, I would suggest that council seriously consider that environment should be reduced now, and that posted speed should be reduced now with the existing traffic on the road to 30 kilometres an hour, given the presence of pedestrians on the carriageway. So I've also looked for examples where that has been applied in New Zealand, and I've at this stage come up with a couple where speed humps have been introduced in rural roads of both 60 and 100 kilometre an hour posted speed environments. So it has been done. And in this case, I see it as appropriate. The road is an isolated cul-de-sac. It's already 60. It's quite short, 400 metres. If the entire road was provided with the treatment that I'm proposing, then you would you wouldn't have any approach speeds that would be greater than appropriate for the first speed hump. Can I just add one amendment though I'd like to make to my suggested mitigation in my evidence? In response to this need to target 30 kilometres per hour, my evidence at this stage was based on cyclists only, and I suggested the location of 2 speed humps. So I'm referring to paragraph 51C of my evidence, where I specified the
Just give me
exact
that
spacing.
reference again.
Yeah.
I've got you 51, isn't it?
Yeah, 51C. I specified the exact location of
That's right. Yes.
of speed humps. I recommend a change to that wording and suggest instead that it should read that the installation of speed humps with warning signage should be now at intervals to target speeds of 30 kilometres an hour. And that I accept may entail some additional speed humps along the length of the road.
Can I just explore this a bit for a moment? And Ms. Brown, I've probably got a couple of questions for you at the same time rather than sort of waiting to come later. If speed humps were not imposed or a condition, or the council, and this is the issue I had before, if the council says it's not appropriate for us to put speed humps in, let's assume so they're not going in, how does that change your opinion about the appropriateness of either the width of the road or the other mechanisms? How key are the speed humps to your opinion that the roading is appropriate or acceptable to the scale that Newnham Park proposes?
Well, it's difficult to be black and white about that, because as I say, the effects of this development in isolation, I believe, are minimal. I believe that the road would be fine for cyclists, because the speed differential between vehicles, it's something like 53, or so between 53 and 58 kilometres an hour currently, based on a couple of different locations, versus cyclists doing about 25 kilometres. And I actually, in my evidence, I have extracted a chart from NZTA, which shows that speed differential of about 25 kilometres an hour is acceptable. However, we've got this pedestrian issue, and pedestrians aren't doing 25 kilometres an hour, so the speed differential is much higher. I guess I would want to see the pedestrians removed from the road.
And I'll come back to
maybe
that,
whether that's by mandatory means or otherwise. Yeah.
And I think I'll come back to that, because I think that, I mean, as you've said to Ms. Brown, I mean, that's clearly a preferred to separate those, the cyclists from pedestrian. I'll come to that. Presumably, if a speed hump will go in, it's not this type, is it? It's that type, is it?
I didn't see it as being very long speed humps. They could be progressively shorter as you go down the road. The first one may be a longer one. In other words, you provide the length of ramp appropriate to the speed approach speed. Once you've slowed the cars down to 30 k's, the following ones would be quite short, simple speed humps.
What does a speed hump do to large trucks?
Well, large trucks would have to deal with those speed humps. In terms of the maintenance issues that Ms. Brown has raised, I appreciate there may be maintenance issues there that could either be dealt with through pavement strengthening, or I would argue that this is work that's required immediately with or without this application, and the maintenance effects I see is take less priority, I guess, than the safety benefits of reducing cars to the appropriate speed. And so, yes, there are maybe potential effects from heavy vehicles, but heavy vehicles have to slow down like everyone else.
Ms. Brown, can I come to you? Because, I mean, both your statements, and certainly your second one, you don't support speed humps. And I know you're a consultant, but you're actually seconded into the council. So I want to ask you in sort of two guises. So one, from your professional point of view about the speed humps, but two, whether you're able to answer from a council perspective, whether the council has a policy or it's something about where it encourages or does not encourage those sorts of limitations on rural roads.
Yeah, so first of all, my professional capacity, I've put in a lot of speed humps and for different roading authorities as well. To get the good speed management properties out of it, you need to make sure that they're spaced appropriately. Sorry. And you'll see that I included a table from Auckland Transport, which do a lot of research on what most appropriate spacings. So that was at about 60 metres to get a 30 km/h speed environment. They need to be shaped appropriately. So the longer tables, they don't necessarily get your speeds down enough. The sinusoidal speed humps, which are the more old school type where you over the top of them. So I've placed those in an urban setting, where they're kind of appropriate, and at those higher frequency repetitiveness of them. In terms of council, we don't have them on rural roads. We hardly have any on urban roads either. To get a lot of kickback from local residents in urban areas around their noise and vibration. And particularly on a longer route, so 400 metres of them, they become quite inconvenient for people, feel that they're very,
Sorry, I'm asking you about wearing her council hat, so you might want to object about this, but she is an expert witness. But I'm interested to know whether the council has any formal policy about, road construction standards which expressly excludes speed humps, because that may be material, or is it just simply that the traffic engineers, you include professionally, don't support them?
I don't think we have a formal policy. It's very informal, and council do take direction from their professional advisors. In terms of in a rural environment where it's got the trucks, and I put that in my statement, they do create this dynamic loading. So a pavement that is currently coping with heavy vehicles that are just moving through the site, the pavement tends to be okay, copes with it, but it does deteriorate much more quickly. Where it has assigned speed humps, you get this dynamic loading of the, as it goes over, it starts bouncing, the suspension in the truck will bounce down the road, and you end up with different damage to the road in terms of maintenance. And so, yeah.
Thank you. That is clear. Your position hasn't changed. Do you want to say more? I've got other questions for you, but is there anything else you want to cover off before I go to questions?
No, I think I've largely highlighted the key matters. I guess the last closing matter I just wanted to say is that I believe with my measures, it'll be a betterment to the environment by slowing those speeds down to the appropriate.
And that's partly what in your opinion, your sort of major proposition as I read it is that the road doesn't need to be widened. And if it was, it would probably encourage vehicles to go faster. I think the speed limit is 60 kilometres at the moment. That's your view, isn't it? So your view is that the road is coped with the consented environment and when they were operating outside the consent. And if it was upgraded to 6.5 metres, that would potentially encourage vehicles to go more quickly. Is it?
Yes, sir. That's correct. And in fact, I think we agree on that point as well.
So I want to come back. And again, you've suggested a number of other upgrades, road markings and signage and signage for the pedestrians. And I think Ms. Brown's position was that will help, but it's not sufficient. That's your position, isn't it?
Oh, well, I guess I was going to add to that. I think an extra sign that could be added, as I mentioned before, is a posted speed environment of 30. That's got to be supplementary to the measures I've outlined, but it does help set the tone for a motorist, a driver coming along and saying, this is an environment I must slow to 30. Yeah.
So, Ms. Ham, this is the question I was raising before, that if the speed environment were to be reduced, that presumably is a council bylaw issue, which you have no control, or your clients have no control over, how would that, this would need to be done in an agreement, wouldn't it, with the council to deal with that sort of.
Yes, and I think the posted speed one, I think Mr. Carlisle does frame that in his evidence as being a supplementary matter for the council to consider. But yes, I agree that with respect to installation of speed humps, for example, they would be on the road, so that would have to be done in conjunction with the council.
Mr. Carlo, you would have, presumably you would have read the submissions from the submitters who raise a number of issues, one of them being traffic and conflicts. Do you want to make a comment on that? I know that your expert evidence is that that it can cope, but can you just want to make a comment on that kind of nature of the conflict and what happens? I.e., do the vehicles just sort of generally on a low speed environment pull off? Are they more courteous? Do they pull off over to the side? How does it actually work in practice?
Well, I have not observed any issues out there myself, and as I said, I've now watched several hours of, in fast time that is, several hours of video near Newnham Park entrances. I see the key conflicts, and I'm not sure that the submitters were focused on this, but I see the key conflicts being those cyclists and pedestrians, not vehicle on vehicle conflict. Yeah. There is a lot of agricultural machinery actually up and down the road. That again has a slightly different speed profile, and I guess that can create a conflict, which is typical of any rural road. But again, the numbers, I guess overall the numbers are so low, both with and without the application, that I do not see any issue.
If it were agreed to have a separated path for pedestrians and cyclists, have you got a particular view of where that should be, which side of the road it should be, and what sort of dimensions?
I think the predominantly there's more space on the north side of the road. It could go either side. There are some vehicle entrances on both sides of the road, and I guess it would be targeting the north side because that would affect less properties, existing gardens and fences that actually intrude into the road reserve. So I guess I wouldn't necessarily say you would needlessly move those. You would try and locate the shared path where it had less effect on everyone. Sorry, in terms of width, I would see the width in the range of 2 to 2.5 meters for a shared path between cyclists and pedestrians. 2 being the absolute minimum. 2, I noted, has been used on sections of the route. In fact, some of the older sections of the route are down to 1.5 meters. The desirable end is 2.5 meters. But again, as I say, this comes back to the funding and keeping the mitigation appropriate to the actual development.
And that's certainly the position the legal submissions cover off. I think my final sort of set of questions to you is you've got this updated survey information in May, which Ms. Brown has made comment on. Do you want to make comment? I mean, and I think saying that it's done at a particular time of the year when sort of kiwifruit function was operating, and the extent to which it's relevant, I think was the question. Do you want to make a comment on that? And I'll ask Ms. Brown her view again.
Yes, well, the surveys were actually targeting the busiest time of year for good reason, because my assessment is usually based on peaks and understanding what the peak volumes are. Of course, the converse argument is we're arguing potentially the traffic is less, but I feel that's not relevant to effects. That's only relevant to financial contributions. And if the traffic volumes are lower at other times of the year, then that should affect the financial contributions and reduce them, in fact. And in fact, on that same basis, the truck numbers I was talking about earlier, if we average the truck numbers over a year, that also affects financial contribution assessments. Yeah.
Thank you. Do you want to make a comment? Because that was how I understood the survey, that it was taken at a busier time of the year when things were functioning, and therefore it probably represented I'll just use it, the worst case scenario, but you seem to have a different view. And I wonder whether you're also questioning the accuracy.
No, I wasn't questioning
you said your
accuracy.
view is that you think it might be different.
I wasn't questioning the accuracy. So I was just pointing out that it was a very busy time of the year, and it seemed that perhaps the applicant was trying to push up the truck volumes for the other users in the network. But it was they're probably there that week and maybe a little bit on the fringe and a few trucks further out throughout the year, but not as much as what was in that peak week. Yeah.
Thank you for that. That's helpful. Thank you, Mr. Carlisle. I think that's all I have now. Ms. Ham, I think this clearly is an issue that your client and the council need to discuss to see whether there is an agreement about what is an appropriate set of conditions. So I think we probably can't take it too much further at this point. Mr. Carlisle's evidence, he's standing by the evidence that he's put forward to me, and I understand that Ms. Brown is doing the same. Accepting, I think that I think both parties accepted a share path would be the preference. If there was to be some form of agreement, that would be the best outcome here. Thank you.
We'll continue those discussions throughout the day. I'll move to my final witness, which is, apart from Mr. Coombs, who's going to come back at midday, but I'll call Ms. Hazen now.
Thank you. Good morning, Commissioner.
Ms. Hazen, just before you start, I think, again, I've read your evidence, and I do note that I think there's not a huge amount of disagreement between you and Mr. Whitaker in terms of the effect, put aside transport for traffic for a moment, in terms, and I'm just really just sort of framing this up in terms of accepting that the appropriate effects have been assessed. I think you both come to the view that, generally speaking, those effects are either no more than minor and can be mitigated through conditions of consent. And I think you both are in the position that the objectives and policies, this proposal is not contrary to them in terms of a non-complying activity. And in fact, you say they're consistent with. So that's kind of where I've got to in terms of the broad understanding. So if that's helpful in your summary.
Yes, it is. Thank you. So I don't propose to go over the points where I agree with Mr. Whitaker. I think what would be useful is to I just want to summarise based on what Ms. Ham and Mr. Carlisle have said about the existing environment, and perhaps focus in on what the differences are that we're looking at here. Mr. Carlisle's explained the traffic generation differences and the split between private vehicles and heavy vehicles. And I think just taking a more simplistic approach, what we're dealing with here is 142 additional trips per day as a maximum. And that's between the consented baseline and the proposal. The proposal would be an additional 33 staff as a maximum, and seeking to formalise some of that weekend activity. And the weekend activity I'll come back to, because there is a slight difference of opinion between Mr. Whitaker and myself on that aspect. So with the existing consents, there's, I guess, an informal allowance for staff during the weekend. The consents mention staff movements, but no heavy goods vehicle movements. And the proposal is to formalise the staff movements, seeking 8 staff in the weekend, to formalise the hours of operation, which is 10 a.m. to 3 p.m, which Mr. Whitaker and I do agree on, to remove any activity from public holidays, apart from perhaps just a single staff visit where they might need to check a cool store if it's during the season. And that would just be a private vehicle, not a heavy goods vehicle. And to reduce the total operating hours during the week from the currently consented 7 a.m. to 7 p.m. to 7 a.m. to 6 p.m. So I think that sets out the differences. I mean, in terms of the intent for the application, it's largely to regularise what is a complex consent framework currently, and to allow for some modest growth of those activities, which is that primarily the increase in staff numbers. In my opinion, the scope of the activities between what's consented and what's proposed is largely unchanged. Newnham Park is not seeking to add different or greater range of activities. And in terms of those visual and physical characteristics that will change, in my opinion, it's an improvement. There will be some of the built form will be removed through removing buildings 1 and 2. That will be replaced with car parking, which will enable all parking to be accommodated on site, which has been an issue in the past with staff and visitors parking on the road berm. And a condition of consent is proposed to require that all activity is parked on site. And then there's some additional landscaping, the acoustic fencing, which you've heard about, and regularising the signage, which has been raised by submitters as appearing to be visually cluttered. So I think there's 3 signs, quite large signs on the frontage at the moment, which you can see, and they would be replaced with 1 single signboard that's shown on the landscape plans. So I think where that lands us is a slight difference of opinion between Mr. Whitaker and myself on weekend activity, which I'll turn to now. In the Section 42A report, Mr. Whitaker recommended some further restrictions on activity in the weekend. And as I understand it, that was related to no heavy goods vehicle movements on a Sunday. The applicant has advised me that they don't agree to that restriction and would like to maintain the proposal to have 8 truck movements across the weekend. So that's 4 trucks, 8 movements. And that would just enable that flexibility that during harvest season, and this is particularly relevant to the kiwi fruit processing company on site, that they, when they've got fruit in cool store, that they, I mean, essentially through the Bay of Plenty, it's a 7-day-a-week operation during that season, and it would be too operationally restrictive. So that's the primary reason. There's no intention to have significant operation on the weekend. It's more for a functional benefit.
Can I ask you a question on that point specifically? In terms of the rural zone, you sort of touched on it. In terms of other properties which have got agricultural production, does the plan limit truck movements to other properties?
No, it doesn't.
No, okay.
And I think you raise a good point in that in terms of the character of this rural environment, it is a working horticultural area. There are a number of orchards, primarily kiwi fruit, in this location. And during that season, which is getting longer every year because the different varieties of kiwi fruit we now have, you can see it working through. Early packing will start February, it'll go through to July, sometimes later, and then the cool stores will still be working through until November. It is busy, and it is not uncharacteristic to have heavy goods vehicles, agricultural equipment on the road 7 days a week. So that covers the point around weekend activity, and the other, I guess, difference of opinion is obviously around this traffic matter. My opinion is that, and what I've heard this morning, if I'm correct, is that neither council nor Mr. Carlisle support road widening. The financial contribution would not include a component for road widening. So where I think that leaves us is, what does a condition look like for mitigation of potential safety effects on Newnham Road? And Mr. Carlisle's view is that there are some on-road treatments that would deal with that. Council's view is that a shared path would be more appropriate, and you've heard Mr. Carlisle say that he's not opposed to that. So I think there needs to be some more work there. I don't think you have enough information to write a condition without that work. That would provide certainty to either council or the applicant. And I'm hopeful that in the course of this hearing, we'll be able to work through that. I don't think there's any other points of contention between council and the applicant, or between Mr. Whitaker and myself. So I'm happy to take questions.
That is helpful. I'm just looking at the recommended conditions that you have proposed and your evidence, and I'm just going back to reflecting on what some of the senators have said. There's this issue of wastewater and stormwater, and I note that Mr. Whittaker's covered off, and you have that regional councils granted wastewater consent, which is clearly not before us. But in terms of stormwater, I think again you've got recommended conditions. Is it your view, from a planning point of view, that those conditions would address? I know we've got the engineering reports, but not an engineer here. But presumably, in recommending those conditions, you've taken advice from those reports and the stormwater engineer, and those are appropriate to address the stormwater effects.
Yes, that's correct. The applicant engaged BCD Group to prepare that design for the stormwater management on site. That's been reviewed by Council's development engineer. I don't believe there's any contention that that would not mitigate those effects, and in my view, those conditions therefore would address that.
It's just that I want to be able to put some of these questions to the submitters that have been covered off. In terms of, again, I asked Mr. Jeffries about this issue of the community liaison group and complaints register, and he was happy to impose it. From a planning point of view, when I read that, and again, I'll put it to the submitters, I read that and I thought, those sort of conditions do get imposed on what have really been really large scale proposals, which potentially have significant adverse effects to be addressed. And in this case, it's been recommended and accepted. But there's also other things like there has to be annual reporting about certain aspects and truck movement. That is it your planning point of view that condition is needed?
No, it's not. My opinion and my original set of conditions did not include it.
I saw, yeah.
However, I acknowledge that there can be some benefit that comes from that. And if the applicant accepts it as they have, then I'm not opposed to it.
Right, okay.
They're only as good as the engagement you get.
Right.
You can't force people to engage, but I do understand this. The community is interested and they're quite active here, so it may well work.
The other comment that I'd like you to, or the other aspect I'd like you to make a comment on, and you really touched on it from a planning perspective, what do you understand the purpose of the rural zone to be? And because I note that a number of the submitters have raised the issue that talking about, and I don't want to take away from anything from the submitters, but talk about we've come here because it's peaceful and it's quiet. And you've sort of talked about how busy these rural environments are. What do you see as the purpose of the rural zone?
I think it can be more than one thing, but I think in the Western Bay of Plenty, and in particular when you look at the objectives and policies of the rural zone, there is a focus on productive rural activities. It's definitely a strong focus. It is the lifeblood of the economy here, and you know the kiwi fruit industry in itself is the biggest horticultural industry in New Zealand economically. So I think it would be insincere to suggest that it is quiet rural amenity that we're dealing with here. There is a lifestyle zone, which perhaps is more like that, but this is a working rural environment, and particularly in this area of Te Puna, it's quite intensive.
Talked about, this is what I've talked to Mr. Coombs about. You've talked about how you think from a planning point of view, the visual amenities improved this by reducing the buildings, car parking on the site and landscaping. So I think that's answered that question, which has been raised. I think. Just check, I've just taken a few notes. You can just check, you haven't got other questions. I've got you here. Those are all asked. No, that's it. Thank you.
Okay, thank you very much.
Ms. Ham, I think those are your witnesses for now. We'll come to Mr. Coombs later on. It's 25 to 11 now. I think what I'm going to do is take the morning tea break because we're slightly ahead of schedule, and to give me and others time to read the submitted statements. I think we'll take a half an hour break. So if we come back at about 11:05, then we can have a cup of coffee and have read these statements. Thank you. And we will then, because it won't be 12 o'clock before Mr. Coombs come. So we'll start with the submitters. And my first submitter on this list is Dr. Robert Nicholas. Is Mr. Dr. Nicholas, you're here. Great, thank you. So we'll start with you after the break. You happy to do it now? All right, okay. If you want to cover yours now and then rather than have to wait. Thank you.
Tēnā koutou. Greetings to you all. Ko mau au te maunga, tauranga moana te awa, ko tāki tumu, te iwi, ko ngā tirangi nui, te iwi. Ko piri rākau te hapu, tāwhiti nui te marae. Ko Dr. Robert Marama te Kamoioa Nicholas Ahau. Today, I am not actually speaking for or against this application. We, that's my wife, Susan, and 3 children, have lived at 2 Waikaraka Drive West, which is directly opposite the Newnham Road, Snodgrass corner for over 33 years. I am a retired medical doctor, and I practiced medicine from 1979 to 2024. That's 45 years. My opinions today are mine and my whānau's only. I have not discussed this with anyone else until today. The Snodgrass Road, Newnham Road, Waikaraka Drive West corner was a quiet corner until NPL started. Remember, I've been here for 33 years. Since NPL started, there's been a large increase in traffic volume. The opening of the Tauranga Moana Omokorua cycleway and walkway has extremely compounded this problem. Today, on a weekly basis, there are hundreds of cars, cyclists, joggers, and walkers. For a small, narrow road, and this is where I disagree with you, this is a very busy road. Any expansion of NPL will dramatically increase the traffic volume, as we have heard. Just some questions. Is Newnham Road a safe or unsafe road? Is Newnham Road, Snodgrass Road, Waikaraka Drive West corner safe or unsafe corner / intersection? Is Newnham Road a narrow road? And then the question comes in, can Newnham Road safely cope with an increase in traffic volume? There's no accident report. I'm not sure why not. And I would like to just speak about this for a little while. Many years ago, there was a horrific and tragic accident on Newnham Road. 2 young brothers were cycling home along Newnham Road when they were both hit by a car. This happened in broad daylight, very close to the NPL compound. Tragically, both boys died. I'd like to apologize to the family who are here today for bringing up this accident. I was the doctor, neighbor who attended this horrific and tragic accident. The memory of this accident will never leave me. Since this accident, there have been no upgrades done to Newnham Road. And only very recently, the speed limit has been decreased to 60 k's. and that's only in the last few weeks. Now, there was another accident that I attended as a doctor neighbour. This accident was on the corner of the Newnham Road and Snodgrass Road, involving two vehicles. Vehicle one, the car was coming out of Newnham Road, turning right into Snodgrass Road. This vehicle had 4 adults in the car. Vehicle two, this was SUV that was coming down Snodgrass Road, heading north towards the Moana. This vehicle had 1 female adult and 2 young schoolboys. The SUV hit the car broadside, that's on the driver's side. Fortunately, there were no fatalities, many minor injuries and very distressed people. A backseat passenger had to be cut out of the car by fire rescue and was taken to the hospital. When large vehicles turn left into Newnham Road from Snodgrass Road to make the turn to go down Newman Road, these vehicles always cross right across the road to the right side of Newnham Road before pulling back to go down Newnham Road. And if you're looking down Newnham Road from my intersection and a truck is going down that road, there is no left or right side of the road. The road is so narrow, the truck almost takes up the whole road. Cyclists. There are a lot of cyclists on the road, and many cycle in groups. And these groups, they take up the whole road. Unfortunately, I did bring some photos that I just took this weekend just to show you all what it looks like when there's a group of cyclists on the road. Anyway, when there's a group of cyclists on the road, vehicles can't pass them because the road is too narrow. I don't believe that Newnham Road is a safe road. I believe it's a narrow road. I think there are some things that can be done to this road, and I've heard on your submissions that there's been, and from the council, there's things that you guys have talked about. Look, I think there's a lot of talking. How about doing something about it? I think if NPL wants to increase their business, and again, I've got no issues with business, having been a business owner, but this will increase the traffic volume. Then surely you have responsibility towards making Newnham Road a safer road. If the council and other local bodies want to increase traffic volume, already there's increased cyclists, but it's going to increase even more. There are many joggers, there's many walkers. There are families walking down this road. Then the council should also take some responsibility to making Newnham Road a safer road. I'm not a road or traffic expert, but I do have 70 years of knowledge, experience, and wisdom, and I have lived on this road for 33 years. Well, sorry, opposite. But I look right down that intersection. Here's some suggestions that you have already made. Widen the road. How hard's that? Make it a dual carriageway. Widen the verge so people can pass safely. Give cyclists, joggers, walkers a safe path. Decrease the speed limit. In conclusion, I hope that there will never be another tragic accident on Newnham Road. I'd like to thank everyone for giving me the opportunity to speak. Tēnā koutou, tēnā koutou, tēnā koutou katoa.
Carter, thank you. As you alluded to, you've heard the conversation that we've been having about what upgrades may be appropriate to occur to the road. Do you have a preference? There was this idea of a separated pathway for cyclists and pedestrians, or other actions on the road, or on the table. Might not be what it is, widening it.
Thank you,
What's
Mr.
your
Hill.
preference?
Thank you, Mr. Hill, for asking me that. But as I said, I'm not an expert, but I would widen that road. That road is too narrow. The truck takes up the whole road. I would also put in a separate path for cyclists and joggers and walkers.
Given you've lived there and you look down the road, can you provide me your observation is what happens when, or how often are there two trucks opposing each other, trucks, vehicles, pedestrians, bikes and cars or trucks? How often is that occurring?
Look, it happens all the time. And someone has to give way. And if there's cyclists on the road, obviously the vehicles give way. They give them chance to go past and move on. I had some photos which I wanted to show this exact thing. There was a car, cyclists are coming from the end of Newnham Road coming towards Snodgrass Road. They're basically taking up the whole road, and the car was behind them and had to wait. Basically followed them all the way up until the cyclists disappeared down Snodgrass Road and Burrell Road. Then the car came down to the intersection. How often does this happen? It happens a lot.
And is it your view that most vehicles are driving fairly slowly, i.e. under that 60 kilometre an hour? That Mr. Carlisle's evidence is that it is effectively a low speed environment because of the nature of the road.
I believe that most drivers are responsible and are careful, but unfortunately there are also people who speed down that road. Some of them might like to chase, but you know that's not appropriate.
Thank you for your kōrero. Thank you very much.
Thank you.
Thank you. So on that basis, we will take the morning tea break now. It's 10 to, and so we will come back in half an hour. Ms. Kane, and then you're up after that. Okay, great, thank you. Thank you, everybody. Welcome back. And we'll continue with the submitters. Ms. Kane, I'll hand over to you. Thank you. I've got your submission in front of me and your speaking notes. So how do you want to proceed?
Thank you, first of all, Ian, for allowing us to be part of this process. And thank you, Commissioner and Council staff, everybody here today. I've just got to try and ensure that I speak to things that my neighbours want to speak about, not just myself. So if you just bear with me, I'll try and make sure so at the end of the day, they don't come to me and say, oh, why didn't you bring this up and why didn't you bring it? That puts me in a difficult position if I just select what to speak to. Something interesting happened this morning, listening to everybody and Mr. Carlisle and others. And I started to go through in my head, is this the right location for this business? Because when you start off from originally a packing house and things start to develop over 20 years, everything changes. And that's understandable, that's business. But I'm always going back to this as a rural zone. And when you've been on a property 56 years, you've got a pretty good understanding of the rural character and what is in this area. I just want to stick to Newnham Road on our corner. So kiwi fruit is only in our area. We don't have gold and we don't have red. So it's only for a very short period of time when the big trucks come in. And as you know, that's normally sometime in May, but it's weather dependent. Mr. Carlisle made notes about a lot of truck movements on the other side. I would suggest that was probably the Bateman property that has 3 lots, and we have probably one of the wettest Mays that we've had for a long time. So we have actually 3 blocks of kiwi fruit at the end of Newnham Road. We don't have any other kiwi fruit in Newnham Road. And with that probably would come forklifts moving from one lot to another, because the 3 lots belong to one family. So that would be understandable that we would have quite a bit of truck movement, forklifts coming there during that very short period of time. We don't, in Snodgrass Road, I think we are probably down to 3 or 4 kiwi fruit orchards only. And Burrell Road, I think we have 1 or 2 at the maximum. 3. So we are not in this very immediate area predominantly kiwi fruit. We're predominantly urban, which is right opposite my gate, and part of Newnham Road. So we're predominantly lifestyle blocks, probably 50-50 for the whole Snodgrass Road, and further down Snodgrass Road and Newnham Road, we're predominantly lifestyle blocks and residential. So it's very important to get that across, because I cannot see that we have a necessity to have a lot of very big trucks coming. Because I also take into account, I've tried to think carefully in Snodgrass Road, and we have big trucks come into tenants' property. They come in to pick up the citrus and the plums. And that's probably one of the biggest plum orchards here in New Zealand. They would come in for probably, I would think, about 4 weeks, because like anything, it's got to come out of the ground and then go off for distribution. If I look at Tahana Road, we have over 250,000 roses. They have to come out of the ground and have an 8-week period when they've got to come out and go. So the heavy truck movement for a lot of these properties is it's condensed down to a very short period of time. And I think that's very important, excuse my throat, and to understand why we are so perturbed, anxious, and you might think dramatic, when someone is wanting 11 trucks, heavy trucks, which is 22 heavy truck movements coming per day. We can't see why that's justified. I work outside most days when the weather's good, and I haven't the last 4 or 5 weeks because it's been too wet for me. But I would normally see a big truck come around about 10 o'clock. The only reason I know, I hear the engines braking coming down Snodgrass Road. And then when they get to Newnham Road, they've got to swing onto the berm. Then around about 1 o'clock or 3, I hear the engine braking again. And you automatically, you stop because you're working down weeding, and you lift your head up because the first thing you think there is an accident, and it's human nature just to stop what you're doing because you know that if there's an accident, you're rushing out there. That's just human nature. So it's very different from a train noise. Engine braking is very different. You can't compare it. So I can't understand why there is a need, and I understand Ian wanting to future-proof his site. I'm not stupid, but to go from those numbers to 11, I can't get my head around it, and neither can the people who are involved in this joint submission. Because you also talk about, well, you need, Newnham Park you talk about this co-location. Now, I'm not a planner, I'm not a lawyer, I'm just like the rest of us, we're just dumb lifestylers. So I understand about co-location because you might have a medical centre and you've got all these specialists, then you have a laboratory where you get your bloods done on an X-ray, and there is a benefit from co-location, that's obvious. But I cannot get my head around why Newnham Park, I know they want to expand, but I look from our perspective that we are a very small country lane. It's no exit. So certain people would choose to go and live in Newnham Road against myself, who was happy to live on Snodgrass Road, because I would expect far more traffic, even buying there 56 years ago. Common sense would tell me far more traffic on Snodgrass Road as against a little country no exit road. They would expect to have a different volume of traffic and noise. Because remember, I'm representing people in Snodgrass Road as against Newnham Road. So then I understand, well, we've got an industrial building down there that's gone from a pack house. But the biggest issue that I see is it has consequences once you start and want expansion, because then you have to look at, is this now, if you want expansion, in the right location? That to me, after listening this morning, which I appreciated, listening to these expert people, is really critical, because you've only got 10 families that live in Newnham Road. Some of them are widows, so they might go out once a week. So some of those families who are in the medical profession wouldn't go out their gate. They go out in the morning to work and they go home at night time. So when you look at the traffic movements from 10 families as against what is proposed from one entranceway of 230 vehicle movements a day, it's very hard trying to put it into perspective, meaning like you feel like it's a home invasion. Your whole life has been turned upside down, to put it in a way, because it's very difficult to explain what it feels like from us who live in this immediate neighbourhood. It feels like your whole environment's changed, which it does. It feels like your quality of life has changed. And right now, that with robotics gone, we have to say it's heaven. We love it, Ian. We love you. Because all this traffic volume, all the noise, we've got back our quality of life. And the quality of life for some people it is part of your environment, your surroundings, your amenity values. It's really critical. And what to someone else might be important would be very different from someone who chooses to be a lifestyler or want to buy an orchard. You have different values. It's a holistic way of life, and you buy into that, and you always look at your district plan. You get your lawyer to look at your district plan before you buy there, because it's your investment. Yes, you feel confident that there should be no commercial or industrial activity right on your corner, right on your road. You take that into consideration. So you've done your due diligence, and no one has any issue with a pack house being made more productive, because these are old buildings, and all the pack houses, there were 2 in Snodgrass Road, 1 in Burrell Road and 1 in Newnham. Zespri took control of the kiwi fruit industry, and with it went the old pack houses. They were no longer compliant. So it is good to turn it into something that is productive. But there comes a point when the size and scale of the business, which the people on this side of the table may not think that 75 staff is a lot. Remember that people that live on my corner, most of them are not accustomed to that way of life. And you also, when you only have 10 in a road, you know who all your neighbours are. So people wave out, they took, that's part of your environment. You may not know them personally, but it's a lovely way of life. So this is really why we are, under the joint submission, don't want it to go to 75. We would like to retain this quality of life, which we feel is a fair balance, being in a very small neighbourhood, where we have residential properties that are right on the edge of the road, remembering they were built probably 80, 90 years ago. So they feel the vibration from the traffic. You hear the braking starting in Snodgrass Road, you still hear it on Newnham Road. Here's the other thing that I didn't realise till the other day. When the trucks go down the road, they drive down the middle of the road. When the cars go down, they drive down the middle. As people here behind me will tell you, the cyclist groups, they all cycle on the wrong side of the road. And this is this peculiar aspect of a country lane that's so short, people use it as if they own it. And because it's so quiet, and cyclists have got their little helmets on and some have got their earplugs on, the middle of the road is used. And that's why you'll find the edges of the road are probably in quite good condition, because nobody drives right on the edge. There isn't room really to try and drive right on the edge. But that's all part of the charm of living in a country lane. So from our perspective, we'd like to see the numbers retain at a level that is a healthy balance, because lovely to expand and look at the economics of a large scale to us, but I appreciate not large scale to these professional people. But we want to keep it all in perspective so that everybody is happy. And I think once you start to want 75 and 230 vehicle movements, you've got to remember that that 230 vehicle movements is for one property. So that basically sums up, I think, in a nutshell, and I've hoped I've got it across on behalf of my joint submitters, why we're not comfortable with wanting an expansion, that if we can keep it at what we consider as a good, healthy balance, knowing that people, we've got residential and that's very important to them. I think if we retained it at 42, then we don't really need to expand the road. We don't need to worry about our council trying to find money to widen the road, put in the cycleway. It solves a lot of problems, because we do appreciate our council is cash strapped. We understand that, and trying to cap rates is also critical, because that is one of the biggest issues in New Zealand for the average household. They cannot afford to just constantly be having these rate increases. So if you can wish for anything, but you've got to pay for it. And I don't know how council is going to keep paying if we want to all widen our roads and do this and do that. There comes a limit to what council can afford to do. So I hope I've covered. I've also looked at for the hours of business. I went online, and of your tenants, only one tenant has listed hours of activity being the weekend. That was Southern Produce. Now, I don't understand why Southern Produce wanted to lift hours of business as 7 days a week, because they're basically, it is their head office. They are in a management office, marketing office ladies. So I cannot imagine for one moment that anybody at Southern Produce, apart from maybe you've left your wallet behind, I can't imagine those people wanting to go back and work in their offices Saturday, Sunday. That is only our perspective, and I'm not saying we're right. But no other tenant had listed their hours of business as being in the weekend. And I think the world is changing. So quality of life for everybody, regardless of where you live, but especially as we've chosen to live in a rural zone, I think to have quality of life and a holistic way of life in a rural zone, with the stresses, with everyday living, with the world environment, to at least have Saturday, Sunday and public holidays for yourself and your families is important, because I see the joy when cyclists in a weekend, mum and dad ride with their young children. It just makes your heart feel good to see this lovely atmosphere. And it's the same for people who live on the road, to be able to know that Saturday and Sunday is their time out. So I hope I've covered everything for my submitters, and if I haven't, they'll give me a kick under the table. But I hope you understand where we do come from a different viewpoint as from people on the other side of the table.
Thank you, Ms. Kane. I think you've certainly covered off the issues that were set out in the submission, so I think that's fine. Just a few questions for you. I understand your position and the group of submissions. I mean, you're essentially asking that if not to grant the expansion, essentially, right. And to retain what's existing in terms of the current consents. But can I pose a few questions to you? Yes, if I find it appropriate to grant consent, and that's not a given yet, I need to hear all the evidence. Ms. Hayson set out in her evidence, and I've been asking them questions about a suite of conditions that if consent were granted, they say would be appropriate. And you might not want to answer these questions because they are about if consent were granted, what form of conditions would you be satisfied with? But the ones which particularly come in terms of addressing concerns of submitters rather than declining it, is this community liaison group. What's your view, which would require the applicant in conjunction with the wider community, and it's listed who they'll be, to meet on a yearly basis, I think, and to talk about issues? What's your view of that?
I had a number of my neighbours at my property yesterday, and Mr. Jones said to me, "Oh, I'm happy to do it." And I said to him jokingly, "Oh, Ian, you're away overseas most of the year." But I think if you pose that to him, because to be fair, I live on the corner. I'm actually on Snodgrass Road, right on the corner. So I have an understanding of my rural character, my rural amenities. But I think that's very appropriate to put to Mr. and Mrs. Langley and to Ian, because they physically live on Newnham Road. So I don't think it'd be fair that I answered that truthfully on their behalf.
It's fine. I will ask that of all the submitters to see what their position is. So your view is you don't have a particular view on it?
No, because I don't think we only had that yesterday. And so it wouldn't make any difference to me because, to be fair, we are distanced a little wee bit further away. And even though it may not be much in a very short road, yes, you might find everybody who's on Newnham Road, and I've got people in the back here who did live on Newnham Road, so I can quite happy after lunch to consult with them and say, this is their viewpoint. But I think it wouldn't be fair because I think I'm privileged that I do live just that little wee bit further away. So I don't want to be out of turn.
Again, in terms of the suggested conditions, have attempted to limit the weekend traffic and the weekend number of people on site. Does that satisfy you at all? There will be fewer people on Saturday, Sunday, and even fewer on public holidays?
I think having people know, anybody, I don't care where you live, if you think you can have quality of life in a weekend, I think that's a more healthy balance, because at least you know that in that time, it doesn't matter what your hobbies are, you have got 2 days that are so-called your space. I think that's very important today. Our world is changing.
So again, if consent were granted, you would certainly support fewer people on the weekends and the public holiday. Yeah.
None of us would have it. There's no anything to do with a gardener coming in, a gardener coming to mow the lawns, check on a call store. That everybody understands that there's a need to keep your grounds tidy. And look, even in Penrose 50 years ago, we did the lawns, we did the garden. That sort of thing happens on a weekend when that's the appropriate time, because they're normal casual workers and they do that. That is just, no one has an issue with that, and that's delightful, because you're enhancing the place by keeping it looking nice, and Newnham Park has always looked nice.
What's your position? And I asked Ms. Hayson this question about the rural zone, and I said a number of submissions refer to come here for this sort of quiet, peaceful life. But you look at the district plan in terms of the rural zone, and it does allow a whole range of activities, including farming activities and everything that entails forestry, rural contractors' yards, and all that is permitted activities. And Ms. Hazen's question was, these are working environments, no limits on traffic movements to other sites. What's your view on that?
I was quite interested when Tracy brought that up because you talk about rural character. But when you buy, you choose what rural area you want to live in. Like, do you want to live out in Paengaroa, or do you want to live somewhere out, different parts of the country, anywhere? So when you choose to live in a particular rural area, there is a reason for that. And here's a good example. 56 years ago, we moved out from, Auckland, and we came looking for a place somewhere, not necessarily Te Puna, but my late husband, he drove in the gate. He didn't drive onto the property, and he said, I want to live here. And it was just the quiet, it was the peace, it was the environment. He drove a little bit further in, and he didn't care. So it doesn't matter. The rural character, you can live in a totally different place, and it might be a totally different rural atmosphere, different character. So I think that's a very difficult question to put to anybody. So some of us have chosen rural Te Puna. It might be because there's a beach at the end of the road, or there's a little, for these people, a no exit road. Or for some of us, that it's a nice balance, that it's not too far from going into Tauranga. So every rural area is very, very different. Like if you went down to down there in Hastings, that's where you have all this heavy truck movement within. You go back to the number of apple orchards. They're everywhere. The whole length of the road is apple orchards. So for a big part of the year, there's big truck movements. That is, the land down there is very heavily populated with orchards. Here in Te Puna, and this part of Te Puna, we actually don't have a lot of kiwi fruit orchards ever. I don't know of one kiwi fruit orchard that's been pulled out in 56 years, but right in our area, which is what we're talking about for this resource consent, we actually don't have a lot of kiwi fruit orchards. So we might be very different from somewhere at Te Puke, where you go down number 1, number 2, number 3 road. The whole road is kiwi fruit. So you can't compare apples with pears. It just doesn't work.
Thank you for that. I think you've made your position pretty clear. What I'm happy for you want to talk to your co-submitters about some of those conditions, particularly that one about the community liaison one. I'm happy to hear from you before we come to the council witnesses. So at lunchtime, we can, if you want to ask them and come back and report what their view is, be very helpful.
Yeah. The other thing I did talk to just info about the bumps, because I feel the people who live in the road, they are more affected than myself. They absolutely don't want it. I talk to my joint submitters, they don't want it. I also think from my perspective, you start to lose that rural character again, which is so important. It's a perception, but once you start to have bumps in a very short road, and I don't think it's ever been it's not about the speed that the trucks or the cars drive in Newnham Lane. It is about the fact that everybody drives down, the trucks, the cyclists, the car. We drive down the middle of the road, and I probably do too and don't even notice it. So I don't think having bumps is going to make any difference with respect. It's about the amount of traffic in a little road where people are living, and we also work on our properties. We don't go off to work. So those people here that have been very active in this process are all people who live on their land but work on their land. So they're working outdoors 24/7, which might be quite different from someone who goes off to work in an office all day. So they're not worried about traffic noise, the engine braking. They don't care how many trucks, how many cars, but you do if you live and work on your property. So you basically eat, sleep and drink it, sadly. But that's, again, why we bought in that area, to have that way of life, which is part of, very hard probably for Vanessa to understand that, but it's part of what we consider our amenity values and our environment.
So they did prompt another question, and again, whether you had a view with your co-submitters, heard the discussion this morning about the road upgrade, about not widening the road, about potentially whether it would be better to have a separated pathway for pedestrians and cyclists. What's your view?
Yes, I talked to my neighbours, again, at morning tea break, definitely a separate cycleway.
It's clear.
Yeah, I did. I discussed that with them.
Okay. Thank you very much for your submission.
Thank you. And thank you, Ian. I'm very grateful for being part of this process.
Thank you. We've got Mr. Coombs at midday and we've got the Langleys coming next. Can Mr. Coombs, is he a bit flexible to after?
Oh, I'm sure if we're not ready for him right at midday, he can just wait until the
Right,
Langleys are
okay,
finished.
right, rather than break
I'll
in the
text
middle.
him.
Okay, thank you. Mr. and Mrs. Langley, do you want to present?
Hey, do you mind if I stand up? It just might be easier.
I'm happy for you to stand up. Someone just check that the recording is okay.
Yep, are you there? Yeah. It's going to be a bit of a struggle for me because I'm not used to this sort of thing. But just on consent for Newman Park, we think any consent should be limited to 37 Newnham Road and not include 45.
So just on that, the only application before me relates to 37. I've got no jurisdiction over 45.
Oh, okay. Yeah, oh, yeah. So that's pretty clear.
That's very clear. Ms. Ham, that's the position, isn't it? That the application is 37. If 45, I understand, is included in the application, which is on hold, but this application is only 37.
Oh, yeah. Okay. Yeah. Yeah. So, yeah. Okay. Oh, also, in the application, there is a statement saying in writing, and given the approval by Shannon Braid of 45 Newnham Road, and she is actually a tenant of 45. So we don't really think that's relevant to the application. It just seems a pointless sort of a thing.
Just on that, any party is able to say that they give their approval. All it means is that they don't want to be, they're happy with it, they need to be involved in this process. So the fact is there are submitters opposing the application is what I need to hear.
Oh yeah, but it still just doesn't seem relevant that she should even, be involved. The hours of operation, the existing hours of operation should remain at 7 to 7, Monday to Friday, with no weekend hours at all. It states in the Western Bay Council 42A document, page 32, paragraph 115, lower intensity activities can occur which have very little off-site effects and may hardly be noticeable. This is totally inaccurate. Newnham Park already breaches their hours of operation by working in the weekends and have done so for quite some time. This is a rural zone and industrial weekend activity should not be permitted. If they want to do that type of activity, they should locate their business in an industrial zone where it is permitted. We want to have a peaceful weekends. We want the current unconsented weekend activity to stop, and we do not want weekend activity to be allowed by this new consent. For all of us, it is something we feel very strongly about, and from our point of view, non-negotiable. We ought to be able to enjoy nice, quiet weekends outdoors, entertaining, having a barbecue with friends and family. And it is out of the question when working on Saturdays and Sundays. And Ian, we're not bothered about the lawns being mowed or the gardens being done. It's the trucks, forklifts, radios, hammering, and metal to metal and compressors that offends us in the weekend. Just on the traffic, I don't agree with Mr. Carlisle's putting speed bumps up Newman Road. I think that's absolutely ridiculous. The road needs to be widened so 2 cars can pass in a cycle track to make it safe for cyclists. It is just far too narrow. Newnham, probably going to double up here. Newman Road is part of the Tauranga Omakaroa cycle track, and the high numbers of our community that use it. And there is no designated cycle track or footpath along the road. I know it's been said before, but cyclists and pedestrians, adults, prams have been used on the road. This creates a dangerous environment for those using Newman Road. Activities. The site was originally consented predominantly on the basis that it was utilisation, expansion and existing pack house and cool store buildings, and to be used for food processing, storage and rural contractors depots. But this makes up a very small percentage of the site that is now used for office space for IT, support, managers, office workers. They have no part in the horticultural sector, and it seems like any company who wishes to pay the rent is eligible. We feel that there should be scrutinisation by the council to maintain the standard. Tapuna is a rural zone and greenbelt. So why on earth are all of Tapuna having to fight the fight to keep out a commercial and industrial business in our environment? This is really to Ian. Ian made a comment that that we bought our property and we knew it was a pack house and we knew how busy it was going to be. This is not a true reflection on the pack house at the time we purchased 47 Newman Road. We bought the 2-hectare piece of land in kiwifruit from Keith and Joanne Garnham in 1996, when it was a small family-run seasonal kiwifruit business operating approximately 3 months of the year, and only Keith and Joanne Garnham and 2 staff were there, and the Garnhams lived on site. The second 2-hectare block was bought by Andrew and Heather Lowes of 45 Newman Road. Both orchards have been extremely productive and therefore lucrative, almost averaging twice the canopy average per hectare. When Newman Park purchased the Lowes property, they promptly removed all the lucrative kiwifruit from the property to make way for their commercial industrial building. The next one's not relevant. I'm getting there, so sorry. We don't know how Ian Jeffries can compare the pack house from a family-run seasonal pack house to a commercial industrial business that it is today. And it is not comparable. We have had offers to purchase our property from Newman Park directors over the years, and the latest was a letter of intent in 2018 wanting to purchase our property to allow Newman Park to expand their commercial business park. We did not wish to sell our property and consulted our lawyers, and we declined the offer. We've owned the property for 28 years. When we purchased the property, we were told that Tapuna was a green belt and rural zoned, and there would be no commercial or industrial developments in Tapuna. Alas, I feel the council has reneged and have decided to allow Newman Park to be a special case. And I honestly believe that this development should never have gone to this. And it should be in a commercial development area, and the locals of Tapuna shouldn't need to fight a wrong decision from Western Bay Council. We don't think that Newman Park even cares about horticulture development. It's just a way their investors can create money, and to hell with the families that bought their pieces of land as the paradise. The lifestyle here on our property is the reason we love it, but Newnham Park are here purely for money. Pile the property with tenants pretending they are horticulture related and collect the money. This is not a place for this type of development. It should be in a commercially zoned area like the Lakes or Malimi Street. And, it's my effort. Yep.
Thank you for that. Can I ask you a similar range of questions that I put to Ms. Kane? I understand your positions are very clear on what you want to happen with this application. Of course, before me, I've got an applicant asking for consent. I've got submitters saying this consent should be refused and stick to the current consented environment. If consent were granted, what's your view of this community liaison committee? Is that something that you would support? Basically, it involves the applicant and a range of parties, including you, who would have the opportunity to discuss what's going on, the operational requirements, and understand the function of the operation. Is that something you would support?
Well, my wife and I sort of aren't really confident enough to be in that sort of an environment, but yeah, I just think that it should be nipped in the bud now, and I just can't see why Newnham Park's allowed to be where it is with the type of work it does. If you drive in the lakes, their little company would fit in there perfectly, and it's just the wrong. It's just in the wrong place, and we probably wouldn't, we'd probably take a back seat on, we're not the sort of people that.
I mean, again, these questions are all predicated on if consent were granted, and I'm just trying to understand, as I said, it's not a foregone conclusion it'll be approved. If it is to be approved, these are the suggested conditions that the applicant is saying are appropriate to, and the word in that is avoid, remedy, or mitigate those adverse effects. So hence, I'm sort of really understanding what you think of those, and I know that your position is it should be refused in its totality. Come to these issues about this rural environment and the weekend and the traffic allowances that the applicant has proposed. So in the weekend, seeking to reduce the number of vehicle movements and also reducing or limiting, not reducing it, limiting the number of people who can be on site. Again, is that something you support?
Yeah. Oh, well, I like the idea of not reducing, but no weekend work. It's just if they can't make their money from Monday to Friday, they're doing something wrong, aren't they? And it's just an enticement to get more tenants in to have that weekend open. I just feel we put up with enough with the schmozzle that goes on next door to be stuck with it on the weekends as well. It's
So the argument follows that weekends should just be no go, no action, and it's left to a sort of a quiet rural environment.
Yep, that'd be
okay.
Yep, I mean that's enough. It's enough to put up with it being wrongly zoned now, with not having to put up with weekends as well.
Do you have a view on this acoustic fence that's going to go down the boundary between the right of way to number 45?
I'm really not too fussed about that, to be honest. The acoustic side of it, it'll just be the parking there, which won't affect us at all. No, the acoustic wall doesn't make any difference to us, to be honest. But we've got a shelter belt there. The acoustic wall we thought was going to go up there when they were going to develop 45 and have traffic go down there. So it's not a biggie for Jenny and I.
In terms of your own farming operation, how many trucks do you, we heard from Ms. Kay and others about, it's a very short season. Do you want to make a comment on that? When do the trucks come to your side, or do they?
But what do you mean by that?
Sorry. Yeah. How does your farm operate in terms of?
We just, it gets picked one day a year, where you've got, trucks and that, and the rest of it is just spraying. Right?
3 trucks in one day.
Yeah, so there's 3 trucks in one day.
That's it.
Pick it, and that's it. Yeah.
Right. So, okay. So very short term, one day.
Yes.
Okay.
Yeah. And that's pretty standard for all the kiwi fruit, really, orchards. It's, yeah.
Understood. Thank you very much. Thank you. Did you want to make a comment? Can I come back to you, sir? You're probably part of Ms. Kane's group. Oh, great. Oh, sorry. Well, then, do you want to?
I'm just going to speak on behalf.
So, all right. So you're Mr. Lockhead, is that right? Right. Thank you. Yes, thank you.
I'm Peter Lockhead. I've known Grant and Jennifer for coming up 30 years when they first came to Puna. And Jenny's asked me to assist her in doing.
Can you just pull the microphone a bit closer?
Okay. Jenny's asked me to speak on her behalf. So in regards to this resource consent application, we'll move on to paragraph 10 of the application. I do not believe you can call this a modest change when you are going from 42 staff to 75. It's not modest in our language. Paragraph 11, to state that the activities on this site are tightly aligned with agriculture and horticulture when one of the tenants existing in an advertising document of their business does not mention the words agriculture or horticulture. Paragraph 12, to state that the traffic and noise to the rural character is minor is stretching the definition of minor. It's a 7-day a week, not a 1 day a week on typical orchards. Paragraph 15, although these comments sound good, but as previously commented on, not so accurate, and I'm not sure why we are changing the trading hours. Paragraph 16, to state that this application is trying to future-proof the growth of the tenants on site, where one of the tenants existing has already stated in a publication that by year 2022, he would be hoping to have staff numbers of 50, and towards the end of the year, be employing 150. It's confusing with the staff number business. Paragraph 17. Yes, as the pre-hearing meeting, it was put forward that there was stormwater and foul water issues, and I see you are now scaling back. We are just going on the adjoining site and scaling up of the hours in trade. Paragraph 18. Not quite sure what you were trying to lead us to here, but if you want to continue with the adjourned previous application, why not go ahead with it now? Paragraph 20. In paragraph 20A, you state that the building 5 is not authorised. Who and what activities are in this building? In C, you state staff numbers up to 42 on the site, and yet previously the publication tells us one of the tenants is going to have 50 staff. Paragraph 21. Yes, we are aware that robotics have left the site, and with some gone, staff numbers are back to normal, but the information is that it's still over the numbers. Paragraph 22. It would be helpful to know staff numbers for each and current activity of businesses from A to D. Paragraph 23. The scope of the existing resource consents, I do not believe the present activities are within. Paragraph 24. This consent is to go back to and back on track for staff numbers, roading, parking, and I do not believe baseline comes into it on the basis that it's not the residents at fault here for not bringing a case against 37. They reported the non-compliancy to the council. The residents can't take the case of non-compliance. It's the council's job. So under the RMA, why are the residents getting penalised to fit in to this baseline RMA requirement? And that'll come up later on, I believe. Paragraph 24. I believe the limited notification was very, very limited. Paragraph 29. I'm confused with the word expansion on site when we are removing two buildings that appear as though they are used as offices. So are the existing buildings remaining going to consume these office people to come into the expansion? I mean, you're cutting back for the resource consent, but expanding. I meant to bring my legal scales to get a bit of balance here. Paragraph 29, traffic. This is interesting that Mr. Carlisle, in his report, only went back 5 years for the accident data. It's a sensitive issue, this one. Also in his report, there's no comment on the intersection between Newnham Road and Snodgrass Road, particularly for truck movements. As I have observed, and I dare say many others, myself included, I might add, trucks having to go well over the right-hand side of Newnham Road and sometimes onto the grass verge to manoeuvre from Snodgrass Road to Newnham Road. Paragraph 30. Fostering a better relationship. Sounds good, but I believe somewhat late. In item 2 in this paragraph, my understanding as a kiwifruit grower is the season is April to June. Item 3, once again, the traffic movement, it is talked about the traffic movements from this site, but there's no comment regarding all the other existing residents that access this road. So therefore, the road widening should be triggered. Paragraph 39. Once again, as previously mentioned, this is not a small growth. This is a large going from 42 to 75 staff. And I'm still confused with this 75 staff numbers. Paragraph 42. This is very good. Who is going to be monitoring that all these activities on site will align with the agriculture and horticulture industry? 44 paragraph. I do not believe the existing consents align with the baseline, as several neighbours have had to complain to council, previously commented. Paragraph 53. Regarding traffic movements, I do not understand taking an hour off the trading times will affect traffic movements. Paragraph 54. Although robotics, when they were operating there, traffic movements and parking was outside the consent, we believe it wasn't only caused by them to be outside the consent numbers. Paragraph 55. Once again, the season for harvesting kiwi fruit is April to June. In respect of orchards down Newnham Road, on average, when they are picked, it would be a 3-day exercise of traffic movements for that orchard, not a year as this application is asking for. Paragraph 58. I'm not convinced that the noise control for the cool store motors on the roof has been addressed. Paragraph 60. I disagree with Mr. Coombs, as there are no other sheds buildings on rural land in either Newnham Road or Waikaraka Drive as large as this property. The nearest is a very small old glass houses used for propagating on Waikaraka Drive. Majority of the people are just lifestyle blocks with possibly an oversized garage to house the boat. Paragraph 64. As previous comments, there has been no discussion on the intersection of Newnham Road and Snodgrass Road. Therefore, the traffic needs to be reassessed. Paragraph 66. Yes, the traffic crash record in the last 5 years is fine, but there's no reporting of many near misses at the intersection of these two roads. Paragraph 67. I disagree with this comment that the increase in traffic is negligible. Far from it. Particularly now that Newnham Road has a cycle lane, pedestrian access to a Makaroa, I think the road widening and cycle lane is justified. It does not have to be a single standalone lane. It could be part of the road. Cost efficiency. World studies have shown us that painting a line on the road for cyclists to stay within doesn't work. It is better to have the width of the carriageway with no markings, as it makes all users conscious of each other. And that's a worldwide study. Paragraph 73. By replacing all existing consents, which should be noted started in 1972 till now. But my question is, who is going to enforce these conditions? Thank you.
Just a couple, thank you for that. First up, what you're reading from, can you file that with the council, Ms. Butler? Just for the record, and I assumed you were reading off your submission, but have you got did you have a separate statement that you were reading? Mr. Langley? I'll come back. What you were reading, what you read out, was that a separate statement? Because I was just following through the submission. What if it's a separate statement? Can you just file that for the record with the council? Thank you very much. Just for that. So, Mr. Lang, are you happy to answer a couple of questions? I need to ask you the questions rather than Mr. Lockheed. Yeah. All right. I wanted to ask you this sort of similar questions. I mean, again, I think your statement is very clear that you're asking that this application not be approved, and then you raise a number of questions about who will enforce it and and those sorts of things. Of course, the enforcement is the responsibility of the council, but there are some conditions which are proposed if consent were granted, like there is this annual reporting where the applicant's required to file a statement with the council, giving a schedule of the tenancies, a copy of the complaints register, as well as this community liaison group. Are those things that, if consent were granted, you think would be useful to have in the consent? Right. Okay.
Yes, that would be useful.
And then there's another condition which sort of attempts to limit the sorts of activities which would be on the site. And this is suggested condition 10, which is they have to be related to the agriculture industry under the following categories. There's research, education, management, administration, processing, and storing. Does that give you any confidence that if consent were granted, the range of tenancies would be limited?
Well, if they were to stay as they are now, that would be fine. But if they're going to expand to different areas, then it's not.
Right. So that's as opposed to the effects of the proposal, your real concern is that how is this whole consent managed, and how can you as neighbours have confidence that what's being consented is going to be adhered to?
Yes.
Okay, I understand. Thank you. Thank you very much for that.
Sir, can I just, through you, I just wanted to ask a follow-up question around the acoustic fence, because Mr. Higley's evidence was that it wasn't required for noise attenuation. Mr. Langley said he wasn't too fussed about it and it didn't make any difference to them. Acoustic fences do come at a reasonable cost. So I just, through you, could I ask for clarity on whether they would be comfortable if the acoustic fence were not proposed?
Thank you, Ms. Sam. I'll come to that in a moment, which is why I was asking Mr. Higley the question. I'll come to you in a second, is that it seemed like it had been offered, but it wasn't required to do. But so Mr. and Mrs. Langley, that was, did you understand the question from Ms. Ham? So, or Mr. Langley anyway, is that the evidence of the acoustics is that the fence is not required to mitigate the noise. And your response when I asked you the question is you're not too fussed.
Going down from the street to the pack house, that the road noise, but it's probably still relevant, the noise of the motors from the pack house. There's a real.
So let's just be clear here. So your view is you don't need it for the acoustic reasons.
I just don't feel it's a real top priority for us.
Right, for that.
Yeah.
And of course, there's the shout about between you and the site. So it's not a visual thing either, is it?
No.
Right. Okay. So you're not. It's not priority to you to have an acoustic fence there.
No, not where they were going to put it from the road
all the way down.
Yeah, but it probably from the pack house to the end of the boundary where all the noise from the
so not the car park aspect.
Yeah, no.
Right. Okay. Right.
That's just.
Tim, is that clear for you?
Yeah. It's just the cool store motors that probably it would be beneficial. Yeah.
So Ms. Howe, do you want to cover that? Do you want to cover that in reply? Okay, great. We'll cover it. Thank you, Mr. and Mrs. Langley. Thank you, and Mr. Lockheed. Thank you very much for your submission. Very clear what you're asking for. Just before we hear from submit, I think we'll just go to Mr. Coombs. And Mr. Coombs is the applicant's landscape expert, and I just want to ask him a question.
Good afternoon, Mr. Coombs.
Good afternoon.
Now, the Commission has read your statement of evidence that's been filed. So I don't think there's a need to even summarise. No, just Commissioner Hill has some questions for you.
Thank you.
Thank you, Mr. Coombs. As I said, I've read your report, the ISMIS report, and I've read your statement of evidence, which in summary says that the landscape effects of this proposal are acceptable or less than minor. A number of the submitters have raised this issue about adverse amenity effects and particularly around adverse visual amenity effects. And I'd just like you to confirm your view or not, having looked at the submissions, whether you agree that the visual effects will be more than minor, is essentially. I know that's not your evidence, but I just really want to put it to you to give you an opportunity to make a comment.
Thanks, sir. Just to summarise the landscape components of the proposal, to me, the majority of the effects is the parking of the cars on the side of the road. So the application involves an expansion and rationalisation of the car parking inside the boundary, which to me, if that's successful, that should take that effect off the road edge and contain it within the site. And then in addition to that, there's some additional tree and hedge planting and a reduction in the scale of the signs. So on balance, it's my opinion that the proposal as it stands could have positive effects because it takes those effects off the roadside and contains them within the site.
Thank you for that. A number of submitters again have raised in terms of amenity, and this might go beyond your scope. So if it does, tell me, saying that even the additional traffic that comes down the street in a rural environment such as this one, a small, narrowish cul-de-sac or country lane, that of itself has effects in terms of amenity. I don't think landscape effects, but in terms of amenity effects. Do you want to make any comment on that?
Well, obviously, an increase in the amount of traffic increases sort of busyness and the visual presence of cars. It's not the only traffic generator down that road. I appreciate it's one of the major ones. I often use the Omokoroa cycle trail myself, so I've seen cars coming and going from that car park at the end of the road. As I said previously, I think that the main effects are the car parking right down at the head of Newnham Road.
Thank you. That's clear. That's all I needed to hear from you. Thank you very much. Thank you, Ms. Ham.
Thank you.
Mr. Jones.
Good day. Can I first, before I present, can I first make a presentation, a submission on behalf of Keiko Witherington? Is that possible? She's just given me a few notes to read.
I don't want to stand too much on ceremony because she was part of the group submission that Ms. Kane was covering. Before I answer that question, I just know I've got your notes too, which are all about that group submission, not so much your own. So just explain to me how it appears that you're attempting to represent this group of submissions, except Ms. Kane has represented them.
I didn't intend to represent the group. I was part of a group, but then I thought, because I wasn't sure in terms of my movements, whether I'd be able to attend this hearing. When I found I could attend the hearing, then I wanted to make a submission myself to demonstrate that I was just as concerned about this lesser application as I was about the previous application.
So it's fine for you to represent yourself, and it's fine if Ms. Witherington has asked you to make some comments on her behalf, you're effectively representing her. That's fine, provided
if you like, I can make them on my own behalf.
No, you can do that. You've just got to be very clear that you're sticking within her submission, which is fairly broad.
Sorry, say again.
The answer is yes to your question, your first question.
I can represent her.
And speak on their behalf.
Thank you.
And then I express, I'm Keiko Witherington, and I withdraw from speaking because I have a very heavy Japanese accent. So I may waste some of my time, but I ask Mr. Ian and Mr. George to speak.
That's fine. So you're authorising to speak on your behalf. Thank you.
Okay. Thank you. So these are reasons to keep the operation low. In other words, to stay with the existing resource consent. To stay with the existing resource consent. Keiko points out 7 weeks summer holiday, total 6 weeks of term school holiday, and long weekends. Up to 14 weeks per year, three and a half months. Kids with parents and grandparents are on Newnham Road and push bikes. Small kids, young people, they bike side to side to enjoy. And they don't cycle at 25 kilometers an hour either. They cycle very slowly. They cycle at walking speed. And Keiko says she doesn't want to increase the risk of accidents. Now, I have a good deal of sympathy with this because I just thought about it. But 5 years ago, my children were 11 and 8, and we wouldn't let our children leave our property to go on to Newnham Road because we considered it, well, the mother particularly, considered it too dangerous to even walk from my drive to the cycle path. Too dangerous. That's Keiko questions.
No, that's fine. I think that's fine. Do you want to cover your submission as well now?
Thank you.
I'll come back more broadly with questions.
Okay. So, hello, my name is Ian Jones. I live at 42 Newnham Road. My entrance drive is directly opposite Newnham Business Park. I bought the property in 2011 when the park was little more than an odd out-of-place curiosity. And I have to say, Mr. Commissioner, that what you saw yesterday on your site visit is a very different site than the one I'm now going to explain to you. So before I raise my objections to this application, I feel I should congratulate NPL on the persuasiveness of their application. If I were unfamiliar with the location and hadn't lived opposite the park for 14 years, I would probably think it fair to allow the application. But I do know Newnham Road very well. I love where I live, and I have lived opposite Newnham Park for 14 years. In that time, they have changed from an odd, out-of-place curiosity to being a daily irritation to then being a dangerous and sightly aberration. The application tells us that Newnham Park has become an established part of the environment in which it stands. The opposite is true. It has become an open sore in an otherwise beautiful rural road. I have included a couple of photographs in my supporting file showing the chaos and obstruction caused by parked cars resulting from the illegal and uncontrolled expansion of the park. I think you've seen those photographs. And although Mr. Jeffrey sounds almost apologetic for the success and expansion of his business in his witness statement, sorry, Ian, he took deliberate actions in defiance of his resource consent conditions. For example, he replaced the existing hedge that hid much of the business park from the road with a timber fence positioned to allow as many cars as possible to park on the side of the road. And it should also be noted that Mr. Jeffrey made no attempt to liaise with the residents of Newnham Road in doing that. And with Mr. Coombs' comments about this application would improve the landscaping, well, you can improve the landscaping without the application. It was where it was. This intensity of parking made it dangerous for me to leave my drive for fear of hitting a cyclist. I have enclosed another pair of photographs in the file showing how my view on leaving the drive was completely obstructed by the indiscriminate parking of cars. It also became clear to me that council were complicit in this illegal expansion of NPL and their blatant disregard of their resource consent conditions. In my supporting file, you will see a number of emails from me to council alerting them to the dangerous circumstances surrounding the site, even alerting them to a near miss occurrence I had personally with a cyclist. I also asked on a number of occasions why they were being allowed to ignore their resource consent conditions. I did not get an answer. council also ignored a petition signed by many of the local residents, 25, I think I recall, alerting them to the dangers being caused by the high volumes of traffic being generated by the Newnham Park development. Point 10 in the legal submission document suggests all of the exceedances demonstrate that the surrounding environment can accommodate and receive a level of activity that is higher than that sought by the application. This is a false statement. The opposite is true. The exceedances demonstrably made Newnham Road dangerous and also demonstrated how out of place Newnham Park is in a rural setting. And when point 14 of the legal submission document states, when assessing a proposal, a consent authority must assume that any conditions of consent will be complied with. Now, I'm sure you're not going to take my legal advice, but when the applicant has shown—
I might if you're a lawyer.
When the applicant has shown by his own admission that he hasn't complied with his own conditions of consent for a period exceeding 10 years, then surely that has to be considered in at least the conditions if one were to give permission. And then I also read point 13 in the legal submission with interest. It states that a decision maker may only consider historic non-compliance issues only if they have led to enforcement action by, in our case, Western Bay. And as Peter said, despite my best efforts, this did not happen. And I would appreciate your good self, sir, asking the council why they took no action. As from my point of view, NPL appear to have been rewarded for deliberately and willfully ignoring their resort consent conditions. It seems to me, and probably everyone subject to resource consent conditions, that with council, it's one law for one and another for those favoured. Expert opinion. I don't doubt the integrity, knowledge, and experience of the applicant's experts, but I do struggle with the concept that the advice is given entirely independently, particularly when that advice is subjective rather than objective. And this is evidenced by the difference of opinion between Pip Brown and Ian Carlisle over the suitability of Newnham Road to take the needful amount of traffic.
I just need to step in here. I think you can question whether you agree with them or not. I don't think you can question their objectivity. They're independent. They've signed up to the Environment Court Code of Conduct. So from where I sit, they're giving expert advice. The fact that they don't agree is not unusual, and that's for me to work through.
I understand. Yeah, and that was my point really. That if you have two experts, they may well have different opinions. And just on my experience of the road, speed isn't the problem in Newnham Road. Generally, most people drive at a sensible pace. But when two cars pass each other, they have to slow right down and they're virtually touching. And if a truck comes down, then I have to drive off the road onto the berm. It is the width of the road that's the problem. And as Peter said, Mr. Carlisle hasn't taken account of the really very dangerous junction at the end of Newnham Road and Snodgrass. It's obstructed by telegraph poles, very bad. The alignment is very confusing. So it's a very dangerous junction. Oh yes, and so I say, most residents would agree with Pip Brown that Newnham Road would need to be upgraded if the application were approved. But the legal submission document suggests in point 30 that it's not reasonable to require NPL to upgrade Newnham Road. Now, I know we've discussed this, but I suggested that argument is self-defeating. If it is not reasonable for NPL to pay for upgrading Newnham Road, then it is not reasonable for them to locate in Newnham Road, in my opinion. The final document I've enclosed in my support file is a submission on the previous application, currently on hold, submitted on our behalf by Inspire Environmental Planners. We paid Inspire several $1,000s for this report on our behalf, and it does offer alternative views to the applicant's planner. So I would appreciate it if you could read it in the context of this new application, because many aspects still apply.
Can I again, just to help you, make a comment? So you presumably you chose not to bring them to this hearing, and you presumably you haven't had, I don't know, have you had them look at this application?
No, we honestly, we ran out of money.
Look, I understand that this is an expensive process for
we couldn't
everybody.
afford to keep spending.
I just need to tell you that I've got it and I've read it, but I can place very little weight on an expert who's not here to present it. I understand the point that they're making. I understand the point that you're making, and I'm happy for you to make them. It's just that I can't receive it as expert evidence.
Understand. That report does talk about stormwater that I didn't think had been addressed in the application, but I think is now being addressed. But it does.
There are conditions, suggested conditions around stormwater, and of course, I think since that previous application and evidence, I think the regional council has then granted a wastewater consent.
Yes, that's right. So the final point I'd like to make regarding expert advice, and I do it with a little tongue in cheek, I humbly suggest if it takes this number of expert witnesses to support an application, then the application is probably in the wrong place. Personal view. The 42A report and other documents refer to the consented baseline. And I understand the legal position, well, try to, in their evaluation of the application. But I would like to make a couple of points. The first is that Newnham Road is an idyllic rural cul-de-sac containing 10 or so properties. Many of us bought our homes when NPL was just an oddity, if that. To all the properties other than NPL, the baseline is the way it was during COVID when NPL wasn't operating. Cyclists sharing the road with joggers and walkers and kids in pushchairs, safely enjoying the amenity. It was the way the road was designed to be in a rural environment. And without any consultation with affected parties, council have allowed NPL to destroy this baseline. So therefore, I can't help but feel that Report 42A makes its recommendations in an attempt to find the path of least resistance out of a monumental mess that has occurred. Why should NPL be given more importance than any other property in Newnham Road? This is a non-complying activity. They have no rights over and above ours. How can we possibly conclude that the effects of 22 heavy truck vehicle movements and 250 car movements in a rural cul-de-sac are less than minor? How can you possibly conclude that the effects of working all day Saturday and Sunday with further heavy truck movements proposed are less than minor? We're powerless to do anything about NPL's current resource consents, but we certainly do not have to aggravate the position. The traffic effect of NPL is currently more than minor. This application alone more than doubles that effect. The business viability of NPL, which is mentioned in the 42A, has no more relevance than the value of our properties. And I believe the tenants of NPL have no demonstrable need to be located there. So in my view, the application clearly does not meet the gateway test of S104D. To sum up, and I hesitate to use this analogy as one situation is very much graver than the other, but particularly with a much larger application on hold, but still showing intent, this application feels like a peace deal. We feel that our rural amenity and culture has been invaded by Newnham Park. And in any peace deal negotiated in Ukraine, the world would not have the power to force Russia back to its borders. But this hearing does have the power to return NPL to the borders of its 2013 resource consent. I ask it to deny the application. Thank you.
Thank you for that, and certainly for the way you presented it. Just a couple of comments, and I've got a couple of questions. In terms of this issue of no more than minor, I just want to say, people use those terms in terms of the assessment of these applications. No more than minor isn't a particularly relevant argument. What the applicant is saying, that the road will function efficiently with the increase in traffic, and the council's expert is saying, look, it needs some changes. So less than minor is not a relevant consideration to me. So the fact that it might not be less than minor, it might be more than minor, doesn't necessarily mean it's not approved.
Isn't that relevant to the gateway test? No.
Well, yes, it is. Sorry, yes, it is relevant. It is relevant to the gateway test. So you're arguing in terms of a non-complying activity. You're saying that the increase in traffic is more than minor. So less. There's less. I mean, there's a whole lot of things. There's less than minor, more than minor, and significant. Right. So your argument is that the traffic effects alone are of more than minor. And therefore it doesn't meet that part of the test. So there's two tests in that non-complying, and then the second one is it contrary to the objectives and policies? Now the expert planners have said to me, at least, that they don't think it is contrary to the objectives and policies, subject to the conditions of consent. Anyway, that's just by way of comment. But I understand the arguments you're putting. So the same questions I put to some of the others, that it's very clear that all of the submitters, and you included, want the application refused. And accept that there is an existing permitted consented baseline which the applicant should be held to. If I found that it was appropriate to grant consent, it comes down the end to what is an appropriate suite of conditions, and what's your view on things like this community liaison group, like this annual reporting, to talk about what sort of tenants are there, who are they, and how it's operated, and also the limitation on numbers of people on site and traffic. Have you got a particular view on that? I mean, I know you don't want it granted, but if it were,
yes, as you recognise, I'm fundamentally opposed. A community liaison group can never be a bad thing. I think it could only be useful if, if I'd be happy to represent submitters if that were the case, if we could be party to the negotiation on the consent conditions, if that is a negotiable element. But we would certainly want to fully understand and have some say in these consent conditions. And they would have to be, on the basis of our experience so far, it's not been good. So,
right.
But, in principle.
So if it's genuine and meaningful, and open and consultative,
it's something we could properly, manage and coordinate. Yes.
Right. And in terms of limitation, what I've heard from all the submitters is don't want this traffic's too significant, it can't be mitigated. But it seems to me that the weekends seem to be particularly important, and therefore seeking to limit the hours, limit the numbers, and limit traffic. Are the limitations proposed appropriate or not? Mr. Langley said no weekend at all.
On the weekend?
Yeah.
No, there's a building company in London that no weekend working. You can't even paint. So anything, just you're not allowed to open the door of your site, your building site. And that's now how the UK in London certainly operates.
Right.
And I see no reason why that shouldn't operate here. The weekend structure here is very important. Actually, I have to say, Ian, bearing in mind the stress from Monday to Friday over the last 5 years, Saturday and Sunday at least have been a relief to go out onto Newnham Road and go for a walk, take the dog for a walk, or what have you.
Do you hold the same view? I think Ms. Kane talked about since robotics have gone that the scale of activity has reduced significantly. And
it's extraordinary. Right. Yes, it's extraordinary.
Okay.
It's sort of back to that curiosity level, but I've only been back a couple of days, so
okay.
But that's.
Thank you very much. Ms. Kane, did you want to make any comments again have you talked to your other people about this community liaison group?
I haven't talked to
You did. We just need you to use the microphone.
Apologies, Mr. Hill. One of the things I was thinking just, up here was, if that was to proceed, you would want a couple of people. So like you had one from Newnham Road and one perhaps up on our corner, which is the corner of Snodgrass Newnham Road, because what might affect someone on Newnham Road, and it's good to have someone to bounce ideas off. So I think if it was going to proceed, I'd like to see not just one person as a representative from our little area, but two people. Because, hypothetically, Ian put his hand up yesterday and I jokingly said, but you hardly ever hear in the country. So I think having two people nominated to be on that is healthy, because hypothetically you could have from Newnham Park, hypothetically 5 or 6 people. So if you just have one person representing all of our neighbourhood, you sort of automatically felt intimidated by this just one of you, and how are you going to get your viewpoint across?
That's fine. So again, it comes down to, you think it would be useful provided it was sort of open, transparent, consultative, and there was appropriate representation. The way the condition is drafted is fairly broad at the moment, so it doesn't preclude any of what you were saying, I think, if it were to be improved. I was really only asking the question because I think, I clearly think it's been offered by the applicant as an attempt from hearing that there's been this concern about the operation of it. And I wanted to make sure that if consent were granted, it's something that would be supported by the community, and because there's no point in having it if no one's supporting it.
I agree. And it's also no point in having it and you give your time to go to these, twice yearly get together meeting. But then if people in the neighbourhood have issues and they're not going to be addressed, you're actually going to resolve nothing. You're just going there as a, protocol to turn up and talk to your neighbours afterwards. But if the issues that anyone would bring up are not going to be addressed and resolved, how are you going to achieve anything? And that's when I've thought about it, because it's a lovely gesture and I think it was a good one. But I also think, how often do you go to these things and you come away from a meeting, any sort of meeting, you think, well, what a waste of time that was. So that's when I'm trying to balance up, would it have a benefit?
Hence my questions. And I think what I'm hearing is that parties think there is some benefit, except there is some reservations. I understand that. Thank you. Thank you very much. Thank you very much. That was very helpful. And thank you for all of those submissions. So those are all of the submissions to be heard. Just check, yes. So what I'm going to do is adjourn for the lunch break now. I'll just talk about timing for a moment. So what happens now is, after the lunch break, we hear from the council officers about what they've heard and whether their views have changed or whether they're recommending anything else. And then the applicant has an opportunity to respond to that, and then I'll adjourn the hearing. So that I'm not going to hold people too long, is 45 minutes enough for lunch for you? So I think we should be fine too. So what I'm going to do is adjourn now. It's about 10 to 1. It's just going to adjourn for 45 minutes and we'll come back then to hear the council officers and then the reply. Thank you. Thank you, everybody. We'll reconvene the hearing and I'll hand over to Mr. Whittaker. I'm not sure what order you want to or how you're going to run this, but I'll just already hand over to you.
Thank you, Mr. Commissioner. I have a brief statement to present to you, which is just being photocopied. So that it's just coming around now, but perhaps we have Ms. Brown and we have Mr. Telford here. Mr. Telford prepared the financial contribution memo and statement. He hasn't got any further material to present to you, but if you've got any questions, they could go to Mr. Telford. And then Ms. Brown has got a few comments that she would like to present to you, and then I can present my statement. That would be acceptable.
I don't, just quickly, just Mr. Telford, I don't specifically have questions. I understand that the memo has been filed with what you're recommending as a financial contribution. And we've certainly heard from Ms. Ham about the applicant's view of that. And I understand that you have assessed that in terms of the chapter in the district plan which enables financial contributions to be enabled. But as I understand it, unless things have changed over lunchtime, there's to be a discussion between the parties about what's appropriate. So I think it's better to leave it to that, to see what comes up rather than me interrogating whether what you've come up with is reasonable or not. So thank you for that. Ms. Brown.
Thank you. I just wanted to recap just a couple of points from Mr. Carlisle made and from the submitters. So Mr. Carlisle discussed the traffic volumes and vehicle numbers, and they were sort of less than the 200, whereas we assess it by passenger car equivalent, which takes into account the heavy vehicle movements and gives them a weighting, essentially. So the numbers that we have is like the baseline plus the local traffic, so baseline consent value, and the local traffic is assessed at around the 216 PCE, and that the new total with proposed total with the local traffic is 428 PCE, so it's almost double. Mr. Carlisle also discussed about the speed differential between cyclists, pedestrians and vehicles. So in a collision or a crash, the severity is dictated by the speed of the vehicle, not the differential of the parties. And the safe system assessment has an accepted value that says that speeds that are lower than 30 k's an hour significantly lower the risk of DSI. So that's where that magic 30 kilometres per hour comes from. We talked about reiterating my memo, and that I still consider the biggest risk remains between cyclists, pedestrians and vehicles on the route. If the extension of the site was not occurring, then the volumes would remain low, and it would be, there'd still be that conflict, but the driver behaviour in those low volume environments is different than once you start increasing those numbers. The additional traffic increases the risk, it changes the driver behaviour. You've got commuters rather than local people who are invested in that area. The increased use of the cycleway and growth as sections of it gets further developed will also have an impact, and that once it becomes more connected and the increased population growth in Omuakoroa, we'll see those numbers increase further as well. A clarification on the speed limit sort of implied that it was a bylaw process. That's now no longer the case. So we have to have a speed management plan or an approved alternative method. So we can't just put out a 30 kilometre/hour speed limit.
Just on that, so I mean, when I sort of said, I just assumed there was some council process. I used that term. So what is the process if it was to happen?
So it used to be a bylaw, so that you're probably correct, but it's recently changed with the change of government, and there's been change in policy around speed and speed management plans. Western Bay had a speed management plan, but it was rejected by NZTA. So we're currently in the process of doing an alternative method proposal, and we're targeting schools in the first instance, and then we'll be looking at district-wide speed management. With that process, you have to submit your proposals for the speed changes to NZTA. where it goes through, they provide scrutiny and it goes through an approvals process through them. If you've got a 30 kilometre per hour, so unlike the bylaw process, where if your councillors agreed that 30 k's an hour was appropriate, let's make it that, we'll pass the bylaw, away we go, we can do it. There's still an element of that, so councillors have to support it and justify that, why we would want a 30 kilometre per hour there. NZTA would generally come back in this instance and say, this operating speed is 53 to 58, how is a 30 k an hour justified? So we'd have to provide justification and often speed management features to say, and it would, for a 30 k an hour, it's more of an urban environment with the shared space zones and all those lovely things as well, which one of the submitters did talk about was shared space. I'd reiterate that those are really targeted around urban environments and slow speeds.
Just on that, is there a community consultation part of that in terms of the council putting forward a proposal in the speed management plan? Or
Yes, there's a 6-week period where the requirement to consult with the community, and they are required. Part of the reason our speed management plan was rejected, it was only 4 weeks consultation period. There's a number of things, but one of them was that the consultation period had not been long enough. So again, just following my review, sitting in here today, I consider that my conclusion and recommendations still stand for the most appropriate treatment of Newnham Road to cater for the change in volumes is to provide a separated shared facility. Do not accept that speed humps are inappropriate in this situation. Acknowledge that there was other speed reduction measures proposed, but they will not significantly reduce the operating speed to get it down to that 30 k an hour. And yeah, that was everything I had noted.
I know from the discussion there is going to be a discussion about what might be appropriate. What is your opinion if agreement can't be reached in terms of what is an appropriate or an agreement? Do you? And I know that the widening of the road has sort of been talked about is not necessarily the best option, but if the separate cycle pedestrian lane doesn't occur, and your view is that the other mechanisms that Mr. Carlisle has suggested are not sufficient, would you stand by your view that the road needs to be upgraded to 6.5 metre? Is that the fallback or not? Well, what would your advice be to me at this point if agreement can't be reached between the parties? What do you think from a traffic management point of view is the appropriate, or is there an appropriate method or methods to address traffic so that the road can function efficiently, and we'll use those terms, not more than minor? Get into the planning realm, obviously, but from a technical point of view, what would it take to make the road appropriate?
So, my opinion is that to cater safely for pedestrians and cyclists on that road, you need to have a separated facility with this increased traffic.
It's helpful. Thank you very much. Mr. Whitaker, I've got your. Are you going to read your statement? Is that what you want? I haven't read it yet, so.
Thank you, Commissioner. This is just a brief statement, and it canvasses matters that we have actually discussed through the hearing today. So I probably don't need to read it out. If I can just read through it and highlight the matters which are pertinent to what we discussed to date, and I think we need to go from here. So I've put at the end of the introduction section, without a resolution of the traffic generation issues, I'm unable to support the granting of consent.
Can you hear Mr. Whitaker down the back? No, can you pull the microphone a bit closer?
Okay, I'll talk directly into the microphone. So I said in the introduction, paragraph 5, that without a resolution of the traffic generation issues, I am unable to support the granting of consent. I think through the discussion today, council and the applicant are very much wanting to reach a resolution on the appropriate methods and mitigation conditions for any road generation effects. So I think there's an acceptance that there are effects there. And I think it would be appropriate to allow council and the applicant some time to see whether or not there can be an agreed set of conditions. If not, what I understand will be the case is that you'll have the evidence from the council team in terms of the specific road upgrades which the council is seeking, and then you'll have an alternate set of conditions from the applicant in terms of what they're proposing, which may be a mix of financial contributions and upgrade works. So I think there's not going to be a case that there's not going to be a mitigation proposal in front of you. In terms of the scope of the evidence, I've just basically, or the scope of the statement, it's essentially around the transportation effects, the proposed conditions and operational scale, which again has been discussed today in my conclusions and recommendations. Much of this, as I've said, has been already canvassed in the hearing today. We had that discussion on scope, and I note that Ms Ham has confirmed at the hearing that there are no scope issues with the current application retracting the earlier roading upgrade proposal. So essentially the tests are those conditions reasonably imposed in terms of the nature of the effects and the matters under which council has control. So we don't have the scope issue that I was a little bit concerned about in the 42A report. There was also a question in the legal submissions as to whether or not there was any reference to the previous application. I don't believe that's the case at all. The assessment and the evidence before you from the council is purely in terms of the traffic generation from the current proposal. There was also a question in the legal submissions as to whether there was a potential double dipping. I think I've clarified that in the sense that there's not a proposal to have a financial contribution and a requirement for physical upgrade works on Newnham Road. So I don't believe that's an issue. And then I've discussed there a little bit more in terms of the council's preference and positions on the road upgrade and contribution measures. I've gone into a little bit more detail in paragraph 21 in terms of the council's position. So it is looking at a 2.5 metre shared path on the northern side of Newnham Road and additional road signage and marking. So that's the parameters of the physical upgrade works that council will be seeking. I think there needs to be some further discussion with the applicant in terms of the actual formation standard. In Ms Brown's evidence, there has been reference to a metalled formation as well as a concrete formation. Concrete is the ideal solution in terms of its longevity and no or very limited maintenance requirements. That's obviously the most costly option as well. We have had some discussions today with the applicant in terms of an alternative being a asphalt surface, which is essentially halfway between metal and concrete. And I think there are some other discussions around those formation standards, which I think council and the applicant will need some time to work through. As I understand it, there's no real opposition or comment from the applicant's team in terms of the financial contribution calculations which have been presented by Mr Telford. So I guess that we'll just leave that sitting there at this stage. In the 42A report, I did propose a series of conditions, including additional restrictions on the operational scale of activities to recognise the rural character and amenity values of the surrounding area. Ms Hayson has responded to those in her evidence, and she has supported the community liaison group. I'll address that again shortly. Has supported some additional weekend restrictions. However, the weekend restrictions for truck movements is not supported, and as stated in the evidence, given the operational requirements for the kiwi fruit process over the harvest season. In my opinion, the framing of any conditions will need to balance two objectives. These are ensuring that any conditions do not artificially restrict the reasonable use of the Newnham Park facility, and equally that any activity should recognise and protect the character and amenity values of the area, which are valued by the surrounding neighbours. The submitter's position has essentially remained one in opposition to the application, although there has been some discussion on how conditions can help limit the activities and respect the values and character of the area. And there has been some discussion around the limitation or the prohibition of weekend hours and activities. In my opinion, the amendments proposed by the applicant are acceptable to a degree and can achieve a balance between operational efficiency and recognition of amenity values. However, I consider that the allowance for heavy vehicles on Sunday should only be permitted for kiwifruit processing over the harvest season, which I understand is March through June. I stand to be corrected on that. I'm not a kiwifruit expert, but so I'm keen to engage with the applicant a bit further on whether we can have a look at tweaking those conditions. I've noted there the allowance for one staff member on public holidays is a little unusual. I anticipate that it's to ensure that should a staff member visit the site on a public holiday, that this does not immediately constitute a breach of consent conditions. So I think I'm keen to again engage with the applicant just around the wording and requirement of that condition. Just a couple of matters arising from the hearing. There's been quite a lot of discussion around the community liaison group condition. I just want to clarify, so that condition is something that I proposed in the 42A report. And one of the reasons why I proposed that is that there was a discussion at the pre-hearing meeting for the earlier application in terms of the applicant stating that they wish to be a good neighbour and that they did accept that through various operational changes and decisions that perhaps there had been a lack of transparency and engagement with the neighbours, and there was very much a willingness from the applicant to say, look, we want to be a good neighbour, we want to engage with the neighbourhood and share what we're doing and to clarify any concerns. And from that point, the impression I got that there was some willingness to accept that as a way forward if any consent was granted. I guess from the submissions that we've heard today, there's a degree of ambivalence, but also, and I think part of that is it's difficult for a submitter who is opposed to an application in principle to then start accepting conditions, because it seems to be giving ground or losing ground in terms of their position on principle to oppose an application. But I do believe that there is merit in the condition. At the end of the day, it will only work if there's goodwill and good faith by the applicant and the parties who may be involved with that liaison group. I've seen different wording. I've tried to make it a fairly broad-based condition. But one of the things I did include in there was provision for an independent facilitator, because I thought that was quite important to ensure that any neighbours or submitters coming to that didn't feel that it was something that was managed and led by the applicant, and that there was an independent person that was going to help facilitate that group if it is to proceed. I guess the other thing that we have discussed today is council compliance process and action, and this was also a matter that was addressed at the pre-hearing meeting. I think council does recognise that it hasn't been proactive in terms of compliance action with Newnham Park. And I think just in terms of a little bit of context, this process has been going on for a number of years now, and I think also there's been various changes to the activities at Newnham Park. There's also been COVID, which goes back a number of years now. And I think what did happen is that the applicant engaged with council and said, look, we know we have an issue here and we wish to address that through applying for a land use consent to rectify any issues. And that position was essentially accepted by council. I guess the thing now is that that position has been there for a number of years, and I think the frustration from the neighbours is that it's been perceived that council has not been doing its job in terms of compliance measures. In terms of conclusions and recommendations, the Commissioner will need to make a determination on the traffic if there's no agreement between the applicant and council. As I say, given Ms Ham's position now on the scope issue. So there's no issue of scope. It's essentially comes down to the merits of the evidence and where that ends up and whether there can be an agreement. So be it. If not, then the Commission will have to make a decision accordingly. In paragraph 31, I remain of the view that the other offsite effects of the increased scale of activity are capable of mitigation, and I still remain supportive of the granting of consent subject to some further refinement of those conditions. As we've discussed, there's still an impasse between council and the applicant at this stage in terms of an agreed package of conditions for those eroding effects. So I do think it's appropriate that we look at a process with an adjournment of the hearing. I haven't shared these timeframes with Ms Ham. I was trying to do that, but I had to get this printed out over the lunch break. And I think perhaps we will look at getting the traffic experts together as soon as possible, hopefully this week. I've then suggested that the council issues an updated set of conditions. And I'm not suggesting that we actually provide any further evidence. It's essentially a set of updated conditions. At that time, we may be able to indicate whether the conditions have been agreed by the applicant, and if not, there's no more commentary apart from the fact that they have not been agreed. I think there probably needs to be some time frame for the submitters to have an opportunity to review and comment on those conditions. And then finally, there would be a right of reply and any final conditions from the applicant. So I've only put those dates there for consideration, just so we've got a bit of a framework there. Thank you. I'm happy to take questions on that and also the 42-hour report.
Thank you. Just a couple of questions, just in terms of those timeframes, because I think we'll come back and we'll discuss that in your reply and how to do it. Because I mean, in most hearings I've been involved in, it's common practice actually for certainly the applicant and councils to get together and see whether they can agree whether the conditions and what generally comes back as a track change version saying this is agreed, this is not agreed, and the reasons why. So that can be quite straightforward. And Ms Ham will comment on the timeframes. I can say I'm kind of agnostic. I mean, this is an application that the applicant's brought. If you need a bit of time to negotiate it and get it right, then that's fine. I too. So we'll deal with that later on. So is it just in terms of the non-complying activity status? Is it your professional advice to me that if this issue of the traffic effects can't be resolved in a way that you say is appropriate, would it be your view then that those effects are more than minor? Or is that something that needs to be nuanced around what ultimately the conditions might be, even if you don't potentially agree with them? I'm just going to, I mean, you know, we've got the two gateway tests. Effects are no more than minor, and then it's not contrary to the objectives and policies. But I've got a question. So if this matter of the transport conditions to mitigate the effect to whatever level can't be met, that satisfies you professionally, would you say that the adverse traffic effects are more than minor?
I think it's probably going to come down to a matter of degrees, because it's not going to be a case that council's putting forward a set of conditions in terms of physical upgrade works and financial contributions, and the applicant is not offering anything. I think what we've heard today, and Ms Brown has confirmed that she definitely does not support the provision of speed humps on Newnham Road, and that would be the most, as I understand it, substantive measure to reduce the speed environment. So if those aren't part of the package, then I would be concerned with what's left on the table in terms of ways to mitigate the effects of the additional traffic generation. I'm anticipating that the discussion between council and the applicant is going to be around the provision of a separate path and whether or not the council and the applicant can agree on the formation or the costings of that. And it may be an option that the applicant's putting on the table that they don't take responsibility for actually the formation of the shared path, but they provide a financial contribution for that. So
in short, you're saying it depends. what the outcome is.
Yes,
Yeah.
I'm feeling more confident that we're going to be in a position where if there's not an agreement, you'll have two sets of mitigation packages in front of you, and it'll be your decision to satisfy yourself that they, one of them at least, can provide that mitigation.
And the corollary to that is that again, same question, is if agreement is not reached to an extent that professionally you think transport has been addressed, does that make it contrary to relevant objectives and policies?
Again, I'm not trying to make this difficult. It is a matter of degrees, because I think it's not a black and white that the applicant's not offering anything. The objectives and policies in the plan will talk about the safety and efficiency of the network. I think we also have to accept that large parts of the roading network aren't up to a fully complying standard, and there are risks with putting any level of traffic generation on large parts of the network which have existing deficiencies. So I think we have to be careful about how we look at the level of additional risk and immediately getting to a position where that would straight away be contrary to an objective and policy. I hope that answers the question. Yeah.
I think it comes back again, it depends, and we'll see what the conditions come back. Ms. Ham's going to tell me too that the two gateway tests are not predicated just on one effect, that you need to look at across all of the effects of the proposal. Excuse me. No, thank you. That's helpful very much. Thank you. Ms. Ham, I'll hand over to you.
So, given that the main issue of contention with the council remains outstanding, I'm actually going to propose that I submit a written reply with your leave.
Yes.
I mean, there are small points that the submitters have raised that I can and will respond to in the written reply, but by and large, nothing the submitters have said today is a surprise to the applicant, nor probably the council. What I would like to discuss is the proposed timetable from here on in. So certainly the applicant accepts that further discussions with the council would be beneficial, and that further discussions between the planners would also be beneficial. And I agree it's quite usual for the planners to submit a set of conditions showing areas of agreement and disagreement. The one thing I do take issue with is a step in the timetable for submitters to comment. And to that, I would say that the submitters have had the conditions through the Section 42A report. They have had the conditions through Ms. Hasten's evidence. There has been discussion about the conditions today. So you have asked the submitters about the community liaison group. You asked the Langleys about the fence. There's been discussion about the length of the kiwi fruit season. It's not usual in my experience to have that step in the timetable. So I would be asking for a direction which removes that step. I am happy with 1, 2, and 4, but I would suggest that Friday 4 July could come forward to Friday 27 June at the end of next week.
So we'll come back to those dates in a moment. And I want to say it is unusual for submitters to be involved in that process, particularly where there is not expert evidence. And again, it's not to take anything away from the submitters. This is with having the experts discuss and come up with what they think professionally is appropriate, and then for the planners to do that. And given we had this discussion right at the beginning of the hearing about this was likely to be a discussion with the council, why was it at pains really to ask submitters what they thought about a range of conditions, certainly in terms of the transport one, the traffic ones. Did they support a shared pathway? Did they want the road widening? So in that respect, Ms. Ham, I think you're correct that the submitters don't get involved in that process. So I think it's a professional to professional basis, and they'll make their recommendation based on their expertise. In terms of the dates, as I said, I'm somewhat relaxed about the dates. So what I'm going to suggest is, rather than we kind of do it by committee here, if you want to file, and again, I completely accept and would appreciate a written reply, because it means that you can then go away and consider all of the relevant aspects. If you want to file a memoranda about our process to be followed and the dates, and you can do that in conjunction with the council to come up with an agreed date. So I'd be happy with that.
Thank you.
Excuse me, excuse me, may I say something?
Yes, but
Thank you.
I might shut you down.
That's fine. But because of this exceptional circumstance that this roadway is so intimate to all the submitters and essentially only the submitters, albeit there are cyclists and so on, I think there is an exception where we should have an input into the decision.
The reason why I've been quite clear and maintain being clear that submitters are not involved in the process is all the submitters have maintained their view that this application should be refused. That's the position that you've all taken. And I've kept asking, I was quite clear saying, I accept that's the position of the submitters. If it were to be consented, what basis might it be acceptable from a range of things, including transport issues? And you've all given me your opinion on that. As I've said, it is an expert area in terms of traffic effects, what the road can effectively and efficiently handle, and then it's a planning issue about how that meets the objectives and policies in the effects test. So on that basis, it is an expert process. So I will leave it to the experts to do. Of course, any outcome of that process that will get fed back to me, that will be public, and you'll all get copies of that. You'll clearly understand the positions of the applicant and the council. And of course, whatever the outcome, if the decision is to refuse consent, clearly the applicant has a right to appeal that. If it's granted, submitters equally again, I know there's a cost to this, equally have an ability to appeal the decision. So it's not as if you've been completely cut out of that process. So thank you for the question, but I maintain my view that it's a professional exercise. So on that basis that I will adjourn the hearing, Ms. Ham will file a memorandum, hopefully within the next couple of days around process. Once we've got that, we can then confirm when the dates are going to be. Again, all of this we put up on the website, Ms. Ham's memoranda, the council's response, any response that I might have to that. Once that's all in place and we've got all the information, I'll then consider closing the hearing. And I'll only close the hearing once I'm satisfied I've got sufficient information to do that. So look, on that basis, Ms. Ham, thank you to your team. Thank you to the council team. Thank you to all the submissions. Thank you for the respectful way that you presented your submissions. I know this has been fraught. I can tell that having read all of the background material. So thank you, everybody. We're on June. Thank you.